और सर से पूछा कि इनको चेक भी करने क्या है। पोस्ट तो ले एक मेरे। हेलो हेलो चेक चेक 1 2 3 चेक।
पीछे बैठे हुए सम्मानित अतिथियों से अनुरोध है कि कृपया आगे वाली सीट पर आ जाएं। प्रथम दो पंक्तियों को छोड़कर आपसे अनुरोध है कि कृपया सभी सीटों को उसी के क्रम अनुसार भरने का प्रयास करें। धन्यवाद।
These are of cess. Thank you.
I request our esteemed guests to kindly take their seats and keep their mobile phone switched off or on silent mode, as we will be starting our program shortly. सभी गणमान्य व्यक्तियों से अनुरोध है कि कृपया अपनी सीट पर बैठ जाएं। कुछ ही क्षणों में हम अपने कार्यक्रम की शुरुआत करेंगे। हमारे मुख्य अतिथि और सम्मानित अतिथि शीघ्र ही हमारे बीच आने वाले हैं। धन्यवाद। Our chief guest has arrived amongst us. I request everyone to kindly take their seats, please. सभी सम्मानित अतिथियों से अनुरोध है कि कृपया अपने स्थानों को ग्रहण करें और अपने मोबाइल फ़ोन को स्विच ऑफ रखें। हम अपने कार्यक्रम की शुरुआत कर रहे हैं। धन्यवाद।
Started. तो आएंगे ना, so they will be coming. Yes, हाँ start. Yes, they are coming.
All the esteemed guests are requested to kindly rise and welcome our chief guest, Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, and guest of honor, Honorable Mr. Justice Satish Chandra Sharma, and other dignitaries on the dais. Thank you very much. Good morning and a very warm welcome to everyone. In Indian tradition, lighting a lamp symbolizes the spread of divine grace. It illustrates how to rise upward and dispel darkness and gloom. तो माँ सरस्वती का आह्वान करते हुए हम आज के कार्यक्रम की शुरुआत दीप प्रज्वलन के साथ करेंगे। मैं मंच पर उपस्थित सभी गणमान्य व्यक्तियों से अनुरोध करती हूँ कि कृपया दीप प्रज्वलित करके आज के कार्यक्रम का शुभारंभ करें। सभी सम्मानित अतिथियों से अनुरोध है कि कृपया दीप प्रज्वलित करके कार्यक्रम को आरंभ करें। धन्यवाद।
To celebrate this historic occasion, very eminent personalities of the country are here amongst us. May I now request Srimati Sulekha Bibi to kindly welcome our chief guest for today's program, Honorable Mr. Justice Dinesh Maheshwari, Judge, Supreme Court of India, with a plant.
अब मैं माननीय न्यायमूर्ति श्री दिलीप गुप्ता, अध्यक्ष सेस्टैट से अनुरोध करती हूं कि कृपया हमारे मुख्य अतिथि माननीय न्यायमूर्ति श्री दिनेश माहेश्वरी, न्यायाधीश सर्वोच्च न्यायालय को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Anjani Kumar to please welcome our guest of honor, Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Delhi, with a plant.
धन्यवाद। अब मैं श्री अजीत कुमार से अनुरोध करती हूं कि कृपया हमारे सम्मानित अतिथि माननीय न्यायमूर्ति श्री सतीश चंद्र शर्मा, मुख्य न्यायाधीश, दिल्ली उच्च न्यायालय को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. C.L. Mahar to please welcome Honorable Mr. Justice Yashwant Verma, Judge, High Court of Delhi, with a plant.
धन्यवाद। अब मैं श्री एन बड़गन से अनुरोध करती हूं कि कृपया माननीय न्यायमूर्ति श्री यशवंत वर्मा को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. M.M. Parthiban to kindly welcome Honorable Mr. Justice Dilip Gupta, President's Chief Stat, with a plant.
धन्यवाद। अब मैं श्री डी.एम. मिश्रा से अनुरोध करती हूं कि कृपया माननीय न्यायमूर्ति श्री दिलीप गुप्ता, अध्यक्ष सेस्टैट, को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Radhe Thallo to kindly welcome Mr. Sanjay Malhotra, Secretary Revenue, Government of India, with a plant.
धन्यवाद। अब मैं श्री राकेश अग्रवाल से अनुरोध करती हूं कि कृपया राजस्व सचिव श्री संजय मल्होत्रा को स्मृति चिन्ह भेंट करें।
May I now request Ms. Jaya Kumari to please welcome Shri Vivek Jori, Chairman CBIC, with a plant.
धन्यवाद। अब मैं श्री हर्षवर्धन से अनुरोध करती हूं कि कृपया केंद्रीय अप्रत्यक्ष कर और सीमा शुल्क बोर्ड के अध्यक्ष श्री विवेक जोहरी को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Vipin Kumar Jain to please welcome Mr. A.C. Jain, President ECGC Bar Association, Delhi, with a plant.
धन्यवाद। अब मैं श्री कमलजीत सिंह से अनुरोध करती हूं कि कृपया श्री A.C. जैन को स्मृति चिन्ह भेंट करके उनका आज के कार्यक्रम में स्वागत करें।
Once again, a very warm welcome to all of you. We are here to celebrate the glorious 40 years of this great institution called the Customs Excise Service Tax Appellate Tribunal, the CSTAT. To celebrate this occasion, we are honored here to have here with us Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, Honorable Mr. Justice Yashwant Verma, Judge, Delhi High Court, and other dignitaries. In any democratic setup, every institution plays a vital role in the country's development. CSTAT, which was established in the year 1982, has played a very vital role in the economic development of the country in the last 4 decades. The CSTAT, through its judgments rendered in the areas of customs, central excise, service tax, anti-dumping, etc., has contributed significantly to the tax jurisprudence in this country. Through its judgments, this institution also has contributed to the uniformity, stability, and clarity in tax administration. All the stakeholders, namely the Ministry of Finance, CBIC, the past presidents of CSTAT, the past members of the CSTAT, the incumbent president, honorable members of the CSTAT, the members of the bar, the authorized representatives of the department, the registry of the CSTAT contributed in their own way in the growth and smooth functioning of this institution. It will not be out of place if I may mention that approximately more than 75 to 80% of the judgments and orders passed by the various benches of CSTAT in the past several years have been affirmed by the various high courts and the Supreme Court of India. This is no mean achievement. In cricketing parlance, this is an excellent strike rate. In keeping with the vision of the Honorable Chief Justice of India to make the justice delivery system transparent and make use of technology, the CSTAT, under the leadership of the President, has taken significant steps to digitize the entire filing system and e-hearing, etc. The proposal through Finance Bill 2023, which is pending in the Parliament, to widen the jurisdiction of this institution to decide disputes relating to central sales tax on interstate trade is another feather in the cap of this institution. Every achievement requires a celebration. The celebration is an occasion to look back with pride and satisfaction what has been achieved, and also to look ahead and see what more can be done, keeping in mind the challenges ahead, and also keeping at pace with the technological developments, etc. For this purpose, we have 2 technical sessions today, in which eminent speakers will share their thoughts with us. Before I proceed to invite Honorable Mr. Justice Dilip Gupta, President CSTAT, to deliver his welcome address, a few words about Mr. Justice Gupta. Honorable Justice Dilip Gupta was appointed as the President of CSTAT in 2018 after his long and successful tenure as a judge at the Allahabad High Court. If there is one phrase that would aptly capture Justice Gupta, it is epitome of patience. The first and foremost task which Justice Gupta undertook on becoming the president is to streamline the entire filing process listing process and the hearing process. During his tenure, the amount of transparency which he has brought in the entire functioning of this institution, both on the administrative and the judicial side, is really commendable. Even during the COVID pandemic period, under his leadership, the benches of CSTAT functioned virtually, and he ensured that all the infrastructural arrangements were in place in all the benches of CSTAT to make the hearings effective and to render justice. On the judicial side, Justice Gupta ensured that all the anti-dumping appeals were given priority and the appeals were heard and judgments delivered speedily, since expeditious and timely disposal was key in those matters. In the last 4 years, even though the CSTAT was not functioning with its full strength because of non-appointment of members, he constituted several larger bench matters, and disposal of those larger bench matters ensured that the issues which are affecting a large number of appeals was decided. Under his leadership, following the sentiments expressed by the Honorable Chief Justice of India, the CSTAT is making every effort to become completely digital, and the e-filing of appeals is already under trial. With these efforts, I'm sure in the months to come, CSTAT will be able to conduct paperless hearings and will be completely digital. The most important contribution made by Justice Gupta in the last 1 year is the appointment of new members of CSTAT and filling up all the vacancies. After very many years, because of his enormous efforts, this institution is functioning to its fullest capacity in all the different benches. With these remarks, may I now request Honorable Mr. Justice Dilip Gupta, President CSTAT, to kindly deliver his welcome address.
"40 glorious years." The logo says it all. Tracing back the journey of 4 decades of the tribunal, from Customs, Excise and Gold Appellate Tribunal, and eventually to Customs, Excise and Service Tax Appellate Tribunal, has been quite enriching, definitely rewarding, and most gratifying. CSTAT, as it is commonly called, has traversed a long way. It is indeed a proud moment for all of us as we gather today to commemorate this occasion. It is with immense pleasure that I welcome each one of you on the dais as also off the dais, as the tribunal hosts this memorable event along with the bar associations and the Customs, Excise and Service Tax Department in this state-of-the-art auditorium of the Delhi High Court. We are extremely grateful to the Chief Justice of the Delhi High Court, Justice Satish Chandra Sharma, for not only making available this auditorium to us, but also for providing support of the registry of the High Court. A very good morning and a very warm namaste to all of you. As we celebrate the completion of 40 years of this great institution, we express our gratitude to Justice Dinesh Maheshwari, Judge Supreme Court of India, Chief Justice of the Delhi High Court, Justice Satish Chandra Sharma, Justice Yashwant Verma, Judge of the Delhi High Court, Shri Sanjay Malhotra, Secretary Revenue in the Government of India, Shri Vivek Johari, Chairman of the Central Board of Indirect Taxes and Customs, and Mr. A.C. Jain, President of the ECGC Bar Association, for having consented to participate in today's function. I am particularly humbled and honored that sitting and former judges of the High Courts, sitting and former chairpersons and members of the tribunals, the Joint Secretary Revenue, members of the board, the chief commissioners, the principal commissioners, and the commissioners are present today. In our midst, we also have members of the tribunal and the members of the bar from across the country. I sincerely thank all of you for gracing this occasion. The commitment of Justice Maheshwari, who hails from a family of lawyers, to the cause of justice and to the institutions delivering it is well known. I must narrate what happened when I went to the residence of His Lordship to invite him to preside over today's function. His Lordship had a prior commitment, but on learning that CSTAT is holding a function to celebrate its 40 years, His Lordship, without any hesitation, postponed the other function to the latter half of the day so that His Lordship could be with us today. Today's date becomes more special as it is a delightful coincidence that His Lordship started his practice as an advocate in the Rajasthan High Court on this day, that is March 18, though 42 years back. In his landmark Constitution Bench judgment in Janit Abhiyan, His Lordship held that the special provisions based on economic structure criteria may not be violative of the basic structure of the Constitution, but the exclusionary clause in the amendment that keeps away the benefit of economic reservation from certain categories would run contrary to the principles of equality and so would have to be struck down. Justice Satish Chand Sharma hails from an eminent academic family. His Lordship became the Chief Justice of the Delhi High Court on June 28, 2022. In a short span, His Lordship has authored important judgments on sensitive matters of both constitutional and social importance, including the validity of the Agnipath scheme. Justice Yashwant Verma hails from a family of eminent lawyers, and His Lordship's father, Justice A.N. Verma, is a retired judge of the Allahabad High Court. As a judge of the Delhi High Court, His Lordship has penned down important judgments, especially relating to the rights of senior citizens, as well as delineating the powers of the National Commission for Scheduled Tribes. Shri Sanjay Malhotra, Secretary, Revenue in the Government of India, is a topper of the 1990 IAS batch. He has been ahead of the curve and has an extensive experience in the power sector, both at the state and the central government level. Shri Vivek Johari, Chairman of the Central Board of Indirect Taxes and Customs, is a 1985 batch officer of the Indian Revenue Service and has an illustrious career. He played an active role in laying down the policy foundation for the goods and service tax. Shri A.C. Jain, an eminent lawyer, is the president of the Bar Association. He has been associated with the tribunal with passion and conviction. A great man once said, "No one can whistle a symphony. It takes a whole orchestra to play it." With these pearls of wisdom and an instilled sense of team spirit, I started my journey as the president of this tribunal in October 2018. Anchored by faith, sailing on and beyond with conviction, I initially took baby steps, which eventually became a leap. Though the sanctioned strength of the tribunal is of 16 judicial members and 16 technical members, vacancies kept piling with passage of time, so much so that in 2022, there were only 9 judicial and 4 technical members with me. The result was that only 4 division benches could be constituted out of the possible 16. As head of the institution, it was my primary concern to ensure that all the vacancies be filled up for effective functioning of the tribunal, and I allow myself to indulge and revel in the fact that all the vacancies have now been filled up. In the past 4 years, scores of steps have been taken for the upgradation in the working of the tribunal. All orders passed by the tribunal are now immediately uploaded in real time on the website of the tribunal. Significant infrastructure improvements have also been carried out, not only at the principal bench at Delhi, but also at the regional benches of the tribunal. During the COVID pandemic period, the tribunal effectively conducted virtual hearings at all the benches and was able to decide more appeals during the pandemic period than during the corresponding non-COVID period. Even anti-dumping matters and larger bench matters were heard and decided during this period. Dynamic website was ushered in place of a static website, and in further advancement, we now have a cloud-based website consisting of two important domains, namely the case information system and an e-filing module. The case information system captures all the data relating to appeals and applications filed before the tribunal. Another excellent feature of this new website is the facilitating of e-filing of appeals and applications before the tribunal. The integration of the data of the tribunal with the legal information management and briefing system aids the union government to effectively monitor cases at every appellate stage. Today is a day of celebration for our institution to honor our history and traditions while glimpsing at the future with confidence and hope. I have earnestly attempted to amalgate the past and the present and capture a comprehensive view of the breadth and vitality of 4 decades. As the president of the tribunal, I am committed to leading it with vision, integrity, and grit. We, as the speck in the institution, have our momentum and ambitions. Let us now move forward together with determination and turn dreams into reality. I am sure this convention will give an opportunity for bringing about better cohesion of approach and better understanding of both objectives and expectations the institution has from all its stakeholders. No one arrives at a moment like this without the help and support of a great many people. With pleasure, I extend my sincere gratitude to all who endeavored with enthusiasm into making this event a success. With approbation, I thank you for being such a wonderful audience. So, with purpose and resolve, we turn to the tasks of our time. Before I part, I am reminded of what Helen Keller said. Alone we can do so little. Together we can do so much. It is so true and so relevant. We will do it together. Hope you have a wonderful day ahead. Thank all of you once again. Thank you so much.
Thank you very much, sir, for the welcome address and the thoughts which you have expressed. Now it's time to listen to our other eminent speakers. May I now request Mr. A.C. Jain, President of the ECGC Bar Association, Delhi, to address the gathering on this occasion. Mr. A.C. Jain is one of the senior-most members of the bar, practicing in SysChat. He has been practicing in this forum almost since its inception. As the President of the Bar Association, he has actively contributed to the various changes brought about in the functioning of the SysChat from time to time.
Good morning, everybody. Honorable Mr. Justice Dinesh Maheshwari ji, Judge Supreme Court of India, Mr. Justice Satish Chandra Sharma, Chief Justice Delhi High Court, Mr. Justice Yashwant Verma, Judge Delhi High Court, Justice Dilip Gupta, President Sestet, Shri Vivek Johri ji, Chairman CBIC, Shri Sanjay Malhotra Sahib, our Revenue Secretary, I welcome Mr. Gurdeep Singh also, he is part of us. He is CDR. He is not on the dais, but he is very much there. And other respected dignitaries, ladies and gentlemen. As the President and founder member of the ECGC Bar, it is my privilege and honor to be part of the 40th anniversary celebration of formation of SESTAT. CGAT, as SESTAT was then called, was established in the year 1982 as the government realized the need for specialized tribunal to deal with matters pertaining to customs, excise and gold control, and it was at that point in time the ECGC Bar was established. As a founder member, I have witnessed both the bar and bench grow from strength to strength, and both have immensely contributed to development of jurisprudence in field of indirect taxation. Given my association of 4 decades with SESTAT and the ECGC Bar, members of both bench and the bar have been and continue to be like family. Therefore, my connection with this institution is both professional as well as emotional. Journey of this institution started from a small establishment in Nehru Place, from where it then moved to a much larger complex in R.K. Puram, from where it has branched to several branches across the country. There have been several monumental changes: abolition of gold control regime, transition to harmonized system of nomenclature, introduction of service tax, to name a few, and creation of regional benches. As a founder member of the bar, I can vouch that both the bar and bench have been extremely agile to organic changes and have both constantly contributed to evolution of taxation jurisprudence and nation building on sound principles. In my view, the announcement made by the Honorable Finance Minister for entrusting central sales tax dispute to SESTAT in the current year's budget is a testament to this. Given that SESTAT has been and continues to be an effective and efficient institution of tax dispute resolution, SESTAT is perhaps the ideal forum for tribunalization of GST matters. I am confident, given the pedigree and rich traditions of our bench and the lawyers at our bar, we will be able to immensely contribute to development of GST, a component of indirect taxes, if the Ministry of Finance is really desirous of giving its hand to the tried and tested, most competent and secure institution, the SESTAT. I would also like to take this opportunity to thank our Honorable President Justice Dilip Gupta and the competent members of SESTAT have taken it to the pinnacle of glory. Justice Dilip Gupta, apart from being an astute legal luminary in the field of indirect taxation, is extremely humble, approachable, and receptive to change, and has not only transformed the SESTAT infrastructure, but has with ease embarked to embrace the e-code mission announced by government and endorsed by Honorable Supreme Court. SESTAT today has thoughtfully devised systems and is truly an IT-driven institution with transparent interface. I conclude by saying that SESTAT has indeed had a glorious past and has an even brighter future. Value set and DNA of SESTAT is ideal. I have no doubt that SESTAT will continue to dispense justice efficiently and even-handedly while bracing up with socio-economic changes which will place it in good stead always in times to come. Thank you very much.
Thank you very much, sir, for your insightful address. Among us is Mr. Vivek Johri, Chairman, Central Board of Indirect Taxes and Customs. Shri Vivek Johri has served in a number of roles encompassing the entire gamut of indirect tax administration, especially the policy formulation. In an illustrious career spanning more than 35 years, he has held a number of charges, including Member Tax Policy CBIC and Chief Commissioner Customs at Nahwa Shehwa, the largest seaport in India. His tenure as member GST saw many significant changes out in GST law and procedure, both for easing the compliance burden on taxpayers and tighter enforcement for tackling tax evasion. I request Shri Vivek Johari, Chairman CBIC, to kindly address the gathering.
Thank you. Namaskar. Honorable Mr. Justice Dinesh Maheshwari, our chief guest this morning. Honorable Mr. Justice Satish Chandra Sharma, Chief Justice of the Delhi High Court. Honorable Mr. Justice Yashwant Verma, Honorable Mr. Justice Dilip Gupta, President Sistat, Sri Sanjay Malhotra, Revenue Secretary, members of Sistat and other tribunals, members of the bar, colleagues from CBIC, other dignitaries and guests, ladies and gentlemen, a very good morning to all of you. It's indeed a privilege for me to be here this morning to participate in the celebrations of the 40th anniversary, the Ruby Jubilee of Sistat. Let me begin by expressing my deep gratitude and heartfelt thanks to the President, Honorable Justice Dilip Gupta, for inviting me. And let me also felicitate the entire community associated with Sistat on this auspicious occasion. I cannot help but reminisce today, because when I joined the service in 1985, Sistat was still a very young organization set up just 3 years ago. I remember quite distinctly that there was an air of expectation, anticipation, about Sistat, at that time known as SIGAT, because it also handled goal control. Compared to the system of dispute settlement that CBEC at that time, was living with for many years. And just to recall, sir, the adjudication of cases and appeals were being handled internally within the CBEC, and then a revision would lie with the Government of India. So it was when Sistat was formed in 1982, obviously the expectation was that the justice delivery system would be independent, it would be fair, and it would be speedy. Since Sistat has almost grown with me in my career, I have a lot of affinity with it. And of course, what I'll give you is only a ringside view, because unfortunately, I've not been part of that vertical of the CBEC, which handles Sistat matters. But I have watched its growth and evolution over these years. I think it's only fair to summarize this experience by saying that, and that's very good news for all of us, that in all these objectives with which Sistat was constituted have been duly fulfilled. I don't think I'd be exaggerating if I were to say that Sistat has really played a seminal role in the evolution of jurisprudence on indirect taxes in India, despite the fact there were several new challenges. New laws, for example, the Finance Act 1994, which ushered in service tax, and more lately, the trade remedies, which deals with anti-dumping, safeguard, and countervailing duties. These were new areas not tried and tested before, on which Sistat has pronounced several valuable judgments from time to time. I also feel that this confluence of minds on Sistat benches, with people with so much experience of the judiciary and people who actually implement indirect tax law in the country, has worked very well as a formulation in delivering justice to taxpayers and importers and exporters. So it's an occasion for all of us to congratulate all those who've been associated with SIGAT and then with Sistat over a period of time, and who have contributed to its grand success. While the quick settlement of disputes and pronouncements, settling doubts about the interpretation of law have definitely benefited CBIC in implementing or applying the law on a day-to-day basis, These have also provided very useful policy inputs for amending the law where necessary, and that is how the indirect tax law has evolved. It's also very heartening to know that the ease of doing business initiatives of the government, which aim at reducing the transaction cost and transaction time for the taxpayer, where we've adopted a life cycle approach to every transaction. And by that I mean right from the time the taxpayer engages with us for the first time till the transaction is completed, we handhold him to ensure that the time and cost of doing business with us is brought down to the minimum. And we've reviewed our processes all along, every step of the way, to whittle down the time taken at each stage. Now, we've been able to bring this up to the point of, in the case of customs, clearance of goods, and it's very heartening for me to share with you that we've been very successful in cutting down the time that we take to clear goods. But disputes that continue beyond that state, sir, are also very much a part of the taxpayer experience. And I think Sistat has played a very important role in making that experience better and speedier. What is also very encouraging is that there's so much coherence in thinking in terms of the kind of reforms which have been launched by CBIC and what is happening at Sistat. To give you an example, we've really adopted technology in a very big way at all stages of our processes to ensure that we deliver transparent services to the taxpayer and we deliver them in the most efficient manner. I think what Sistat has achieved by updating its website recently is a very good example of how transparency helps the entire system. And I was just going through the website on a couple of occasions in the past, sir, and like you said, every detail of a case, right from the time it's filed, and its status on a particular date, orders that have been passed, cases that are listed on a particular day, everything is available for a taxpayer to view and see. Now, of course, where disputes, we've tried our best also through our reforms to ensure that disputes come down. But I don't think we can eliminate them totally. So where disputes do occur, our effort should be to settle them quickly. The national litigation policy also aims to achieve the same objective. Now, I just have a couple of suggestions to put on the table, and these are just ideas which I hope would be taken in the right spirit. So it's been our experience that because of the thresholds that have been prescribed under national litigation policy, there are certain cases where we don't appeal owing to the fact that the tax involved falls below a certain threshold. Subsequently, the same issue may come up in other cases. And I would urge the members of Sistat to very consciously apply themselves to those issues so that we can benefit from pronouncements that are made on the issue, lest they go by default. Likewise, when we talk about compression of timelines, one of the suggestions which I would like to place on the table is whether we can review some of the timelines, such as cases where orders are reserved. Is there scope for compressing the delivery of orders there? Virtual hearings, which President Sistat talked about, have been an immense success, and they've been received very well by the trade. That has been our experience in our original adjudications also, and these complement the government's efforts in concluding cases quickly. Could we use analytics for judging the overall efficacy of our justice delivery system in indirect taxes? And this is something we're trying to do, sir, on the CBIC side, where we're looking at the kind of disputes that are generated, trying to develop a typology, and then attempting to address them through suitable policy measures so that the scope for disputes itself reduces over time. I think there is tremendous scope that technology offers in using analytics for working on the judgments that Sistat have delivered and disputes that have been brought up to them. Um, Also, a bigger concern I have is whether we can think of converting or transforming our entire system of tax administration into a learning system. So even though we learn, as I said, tremendously from the case laws that SISTAT delivers from time to time, but that is on a case-to-case basis. I just wondered whether there is any scope for greater interaction between members of the bench and the department. It could be in different geometries, it could be workshops, it could be roundtables. I really don't have a prescription for it. So that mistakes that occur repeatedly by officers who are implementing the law, particularly in terms of principles, and not necessarily in a particular case or based on facts, could be flagged to us, and then we could build those into our training system, into the discussion that we have with officers who are actually adjudicating matters, so that disputes themselves, come down quite substantially. I think that will be a very useful step to take for the future, and I would really urge the President and members of SISTAT to consider that, and I'm sure they would. So let me conclude with that, and I once again congratulate everyone on this great occasion, and I once again thank the Honorable President for having me here this morning. Thank you very much.
Thank you very much, sir, for your address. Our next speaker is Shri Sanjay Malhotra, Secretary, Revenue, Government of India. Shri Sanjay Malhotra is an IAS officer of Rajasthan cadre of 1990 batch. With demonstrated leadership and excellence in his career of over 30 years, Shri Sanjay Malhotra has worked in multifarious sectors including power, finance and taxation, information technology, and mines, etc. Presently, he is Secretary, Department of Revenue, before which he was Secretary in the Department of Financial Services. He is an engineering graduate in computer science from Indian Institute of Technology, Kanpur, and has Masters in Public Policy from Princeton University. I now request Mr. Sanjay Malhotra, Secretary, Revenue, Government of India, to kindly address the gathering.
Honorable Justice Dinesh Maheshwari, Judge of the Supreme Court, Honorable Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, Honorable Justice Yashwant Verma, Honorable Justice Dilip Gupta, President of SESTAT, members of SESTAT, other tribunals, other dignitaries on the dais, my colleague from the CBIC, Mr. Vivek Johri, ladies and gentlemen. A very good morning to all of you, and first of all, a big thank you to President Justice Dilip Gupta for giving me this opportunity to be present over here. It's indeed a very proud privilege for me to be present amongst this august gathering. I also take this opportunity to congratulate and felicitate the whole of the SESTAT fraternity on this momentous occasion, having completed successfully 40 years of its existence. And of course, it has made a number of strides from very humble beginnings, as was mentioned by some of my previous speakers. I would also like to place on record appreciation for the SESTAT, especially in the last few years, the work that has been done, whether it is on technology, whether it is on the administrative side, and very happy to note that while the cases, is going through the pendency of the cases, that's been a constant challenge for all of us in the country, with so much of population, so much of litigation. And I found that, the number of cases have actually not gone up, other than, for the last year. And that is, again, as was mentioned, because of the vacancies. The vacancies are now over. We have a full bench, And I'm sure, number of challenges being taken up by SESTAT, and they have made the impossible possible, if I may say so. And this is again, a big challenge amongst all of us. Is the huge number of cases still with us. Number has not increased as the saving grace, but the number is high. 80,000 cases is a lot. The pendency is about, on average, I would say, it's about 4 to 6 years, given, that about 15 to 20,000 cases are registered every year. So we are disposing, as many, but at the same time, we are not able to reduce the backlog. And so as Chairman CBIC was mentioning, what is it that we can do to reduce this, to expedite this? President Justice Gupta mentioned that we can do it together. Well, certainly, we are there with you, the CBIC, the government. We have been able to fill the vacancies, as you mentioned. You are using a lot of technology. I was happy to see that in the deliberations today that you are having to not only celebrate the successes that we have achieved, but what more can be done and how we can achieve speedy justice. So there is one topic, on speedy justice through technology. And so how we can actually use technology and other means to reduce litigation should be, I'm sure, the deliberations of the day will come up with suggestions as to how we can do that. Along with that, I think it's very important that how do we reduce litigation in itself? And over there, Chairman CBIC, of course, mentioned that there needs to be more interaction, more learning of our officers so that we don't go wrong. At the same time, there is also a need, perhaps, for bringing in clarity in our laws, in our rules. And so what I would suggest really is that we all together, it's for us to do it. And so what we will do in the government, and we'll seek support from SESTAT, and of course CBIC is with us. We'll set up a group, I think, and see as to how we can reduce, first of all, litigation, the fresh institution, and at the same time, how we can reduce the pendency, whether it is, as mentioned, by simplifying law, by clarifying the law, so that by training. So what are the various ways that we can actually, have to reduce fresh institution and at the same time provide for expeditious pendency, expeditious disposal of whatever are the cases pending. And so with these words, I would again like to congratulate the whole of the SESTAT for their glorious 40 years journey and wish you all the very best for the future. As President Gupta said, we'll do it together. These challenges are there, and I'm sure together we can do it. Thank you.
Honorable Mr. Justice Yashwant Verma. Justice Verma graduated from Reva University in 1992. As an advocate, he has handled a wide variety of matters relating to constitutional, labor, corporate and taxation laws. He was appointed as an additional judge of the Allahabad High Court in 2014 and took oath as permanent judge of the Allahabad High Court in 2016. Thereafter, he was appointed as a judge of the Delhi High Court on 11th October 2021. Justice Verma has a distinguished legal career spanning over 3 decades, during which he has made significant contributions to the Indian judiciary. His judgments are widely cited and known for their clarity and depth of analysis. During his tenure at Allahabad High Court, he has authored several landmark judgments with Honorable Justice Dr. D.Y. Chandrachud and Honorable Justice D.B. Bosley, the then Chief Justice of the Allahabad High Court. He also has authored various judgments in Delhi High Court on the subjects of arbitration, money laundering, and rights of sexual assault survivors, etc. May I now request Honorable Mr. Justice Yashwant Verma to kindly address the gathering.
Good morning, everyone. Justice Dinesh Maheshwari, with whom I had the honor of sharing my first day on a bench as a judge of the Allahabad High Court. Chief Justice Sharma, under whom I have the privilege of serving here in this High Court. Justice Dilip Gupta, with whom I have had many occasions to sit and preside over very contentious issues which always seem to arise in UP. Mr. Jory, Mr. Malhotra, Mr. Jain, ladies and gentlemen, good morning. It gives me immense pleasure to be amongst all of you to celebrate as CESTAT completes its 40 years, and 40 glorious years, in fact, as the caption rightly puts it. Reportedly, 51 to 53% of the governmental revenue is made up of indirect taxes. These taxes are generated every time a hammer is struck, a service is rendered, a ship crosses borders. Business and industry constitute important sinews of the nation. And it is these sectors which are directly impacted by these taxes which come to be levied. It is thus important that we have an adjudicatory mechanism. In fact, it's vital that we have an adjudicatory mechanism which is efficient, responsive, fair, and transparent. And CESTAT constitutes the cornerstone of that regime. It has, over the years, discharged its function and obligations with great aplomb. And an interesting aspect of CESTAT, which has always struck me, was the successful amalgam of the administrative members who come with the experiences gathered from various fields of service and its judicial members. Both of them together have given great shape to taxation precedents which have been rendered on the subject over a period of time. And I'm sure that it will continue to do so in the future. CESTAT has had the good fortune, and I can say that unhesitatingly from personal knowledge, of having Justice Gupta as its captain. Justice Gupta had been charged with the mammoth task of enabling one of the largest high courts in Asia to adapt to technology. And he did that with carrying forward the digitization dream of the Allahabad High Court. While closing, I may only say, and I pick up from what Mr. Jory and Mr. Malhotra mentioned about analytics. Well, analytics, so far as judgments and orders are concerned, yes, they do play an important role. But analytics, in fact, should start from the stage where we frame our laws and how they would impact people and how would they impact processes. I'm sure these and other issues will be considered in your working sessions, which are to be held today. Thank you very much. I wish CESTAT the very best in the coming years.
Thank you very much, sir, for your address. Our guest of honor for today's program is Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Delhi. Justice Sharma got enrolled as an advocate in 1984 and became one of the leading lawyers in Madhya Pradesh. Justice Sharma is an avid reader and a part of Advisory Board of National Law Institute, University, Bhopal, and also other law colleges. In 2003, he was designated as senior advocate by High Court of Madhya Pradesh, being one of the youngest senior advocate in Madhya Pradesh High Court. He practiced in constitutional, service, civil, and criminal matters. He became judge of Madhya Pradesh High Court in 2008. Justice Sharma was the chairman of Computer and E-Court Committee in Madhya Pradesh High Court, and under his tutelage, the Indore bench of Madhya Pradesh High Court became the first court in country to provide online certified copies of court orders to advocates and litigants. He also served as judge in Karnataka High Court. In 2021, he became the Chief Justice of Telangana High Court, and in the next year, he was appointed as the Chief Justice of Delhi High Court. May I now request Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, to kindly address the gathering on this occasion.
Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, Brother Justice Yashwant Verma, Judge High Court of Delhi, my sister and brother judges of Delhi High Court, other high courts, and former honorable judges, Justice Dilip Gupta, President, Sestet, New Delhi, Mr. Sanjay Malhotra, IAS, Revenue Secretary, Mr. Vivek Johri, Chairman, Central Board of Indirect Taxes and Customs, Mr. A.C. Jain, President, Sestet Bar Association, New Delhi, judicial officers, members of the bar, officers and officials of the registry, and all other who are in attendance today. I wish you all a very good morning. Ladies and gentlemen, today we have gathered to celebrate the journey of the Customs, Excise and Service Tax Appellate Tribunal. Established in the year 1982, the tribunal has successfully completed its 40 years last year. I look at the journey of this tribunal as a journey of a specialization in the field of law. The underlying idea behind the establishment of tribunals was to secure expert adjudication over certain subjects. The domain of taxes constitutes an integral part of a sovereign economy. At the same time, having a robust and stable system of taxation advances the ease of doing business in an economy and plays an integral role in the national growth. The tribunal seeks to achieve a balance between competing interests by harmonizing them in the form of effective and specialized adjudication of disputes. Today we are having two sessions, and the first is use of technology in tribunals for speedy delivery of justice. I would like to bring it to your kind notice that during COVID pandemic lockdown, under the chairmanship of Honorable Dr. Justice D.Y. Chanchur, E-Committee, Supreme Court of India, we drafted video conferencing rules, live streaming rules, and during the entire lockdown, not even for a single day, the court's functioning was shut. People were arguing cases from UK, from USA, from all over the globe. And I must tell you that Delhi High Court is one High Court which is paperless. Each and every judge works with a desktop. Lawyers come with their iPads. There's no paperwork in Delhi High Court. And I was told that this is continuing for the last 8 years. It's not something new which has come into Delhi High Court. The use of technology is helping us in translating judgments. Recently, Justice Verma is the chairman of a committee which is translating judgments in Hindi. Large number of judgments have been translated. Our district courts are connected with video conferencing. And now we are making, the country is making an effort under the guidance of Dr. Chanchur that all courts in the country becomes paperless and video conferencing facilities available everywhere. So it's a very important subject which is a matter of discussion today. And one of the main speakers, Justice Sanjeev Sachdeva, he is the one who started paperless court in Delhi High Court. I may also take this opportunity to call upon the members of the bar, especially the younger members, to strive for specialization in certain subject matters of law. The tribunal practice has opened crucial avenues for the advocates to constantly evolve and apply themselves into complex matters that require expertise at both ends of the spectrum. Today, I may also take this opportunity to suggest that our tribunals, like regular courts, must embrace technology and must strive to evolve better process through technology. I am hopeful that it would not only make our tribunals more accessible to the litigants, but also address the issue of delay to a great extent. With this, I heartily congratulate the tribunal for the successful completion of 40 years and express my earnest hope that the tribunal would continue to evolve and contribute towards nation building for decades to come. Thank you and Jai Hind.
Thank you very much, sir, for your address. On this momentous occasion, the SESTAT has also published a souvenir containing articles authored by various eminent personalities. May I now request our chief guest, Justice Dinesh Maheshwari, our guest of honor, Justice Satish Chandra Sharma, and other dignitaries on the dais to kindly release the souvenir. Thank you very much, sirs.
The chief guest for today's program is Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India. Justice Maheshwari graduated in science from Maharaja's College, Rajasthan University, and then got his LLB from Jodhpur University in 1980. His lordship enrolled as an advocate in 1981 and started practicing before the Rajasthan High Court in a wide variety of constitutional and civil matters. His lordship took oath as the judge of the Rajasthan High Court in September 2004. Before his elevation to the Supreme Court of India in January 2019, his lordship served as Chief Justice of the High Court of Meghalaya and also Chief Justice of the Karnataka High Court. Justice Maheshwari has authored several landmark judgments dealing with direct taxes, constitutional matters, and criminal matters. He has authored the lead judgment in the recent case whereby the Supreme Court, by a 3-2 majority, upheld the 103rd constitutional amendment providing EWS reservation. Justice Maheshwari was also part of the bench which decided the landmark judgment in Vijay Mandal Chaudhary. The Supreme Court in this case upheld the constitutional validity of the investigative powers of the Directorate of Enforcement and the powers of arrest, bail conditions, etc. under the Prevention of Money Laundering Act 2002. May I now request Honorable Mr. Justice Dinesh Maheshwari to kindly address.
Very good morning to all. Thank you so very much having invited me and having given me this opportunity to be with all my colleagues. My brother, Justice Satish Chandra Sharma, Chief Justice, Delhi High Court. My brother, Justice Yashwant Verma, Judge, Delhi High Court. Other honorable judges of the High Court, past and present. Brother Justice Dilip Gupta, President, SESTAT, the chairpersons and members of all the tribunals, Mr. Sanjay Malhotra, Secretary, Revenue, Mr. Vivek Johari, Chairman, Central Board of Indirect Taxes and Customs, and the members of that board and other boards, Mr. A.C. Jain, President, ECGC Bar Association, Delhi, the senior advocates, other London members of the bar, the members of the registry of the High Court, and the staff of the SESTAT, the other staff members, ladies, gentlemen. It's indeed my immense pleasure that I address you today to commemorate this 40th anniversary of the establishment of the service of this Central Excise and Service Tax Appellate Tribunal. Earlier we knew it as CIGET. The last 40 years have definitely been a period of great success, accomplishments. Of course, the success was tested is a matter of pride for all of us. And as rightly indicated by the speakers of the day today before me, is a day for us to reflect as we look back and then to rededicate ourselves to the values of this tribunal and in fact the entire justice delivery system while looking forward in anticipation of the years to come. A few pertinent points have been made by the learned speakers today before me. If I may underscore a few of them particularly as regards the emphasis on fraternity, as also the emphasis on reducing litigation, and then making the justice delivery system itself more clearer, apart from being fair and transparent. Before I touch on those few of the relevant points, few quick points, friends, I'm tempted to make as regards the trade and commerce, which is at the root of all what we have been discussing, particularly we would be discussing in this today while rededicating ourselves to the cause represented by SESTET. The trade itself has had a long and important history in India, with both internal and external trade playing important role. Ease of doing business, as we are talking about, in fact, it also has its roots in the remotest past we could think of. When we go to the ancient civilizations, we even look at the ancient texts like Rig Veda also, where we find trade being indicated with particularly the Indian seafarers having established themselves as the skilled navigators and taking the things across the globe. And then this particular subcontinent with its unique position had been having always a unique place in the global trade too. Coming to, just the history of a few centuries back, and Britishers came here, and then over the time they came here essentially for the purpose of trade itself. But then over the time so many things took place, including as to how even our freedom struggle took its first seeds, but the first seeds were sown when something like that salt hedge was created in order to prevent the smuggling of salt and drawing a line across the subcontinent, starting from Kashmir to Orissa, and then the struggle to eliminate those impositions or intrusive taxation, that from where it all started. So we can definitely take cue from the fact that the trade, the instinct of progressing further by way of trade and commerce has played its important role in even giving the shape to what we are today. When we rededicate ourselves to, and when we reread Article 51, capital A of fundamental duties, and the first requirement when we will remind ourselves for the citizens to cherish noble ideals that led to our freedom struggle, let we remind ourselves that trade and commerce and any intrusion into the trade also played a great role in shaping our freedom movement. Coming to the present days, friends, when we are having now unique status, a recognized status in world over as regards the trade and commerce. And with our anxiety to progress further, to anxiety to make the things again and again more better, well, ease of doing business or ease of doing things is not simply a rhetoric, not simply a slogan to be read. In fact, slogan to be read or reiterated. This is what we as collective whole are committed to, and that is how we are taking nation forward, where the nation will enhances as a whole, as a society, well, in the all individual as also collective endeavors. Friends, when we talk about the litigation, and particularly when the tribunal and 40 years of glorious existence of this tribunal, and very many more years to come with more of the expansions also likely to come, we discuss. Well, there are several things of challenges particularly which we discuss, and I'm sure challenges as also the way out, as also the way forward would be discussed during the course of this particular day and very many other days also. I'm tempted to say that trade and commerce involving contractual relationship of individuals or compacts like companies, as also the statutory relationship of the traders with the governments and the administration, perforce lead to various forms of disputes. Then simultaneous anxiety of the society has been to look for the resolution of disputes, enforcement of laws, and penalization of defaulters. All these things go together. Mr. Johari indicated in his address that we need to look at reducing the time and the cost. Regular dialogue for that matter is required amongst the stakeholders. This is a very important aspect and feature. I want to underscore rather than it's indicating on several other features. As regards the existence of the tribunals, we all know that, but yes, I'm tempted to remind all of us that 42nd Amendment to the Constitution, well, a lot many things which were done by way of 42nd Amendment to the Constitution was undone by way of 44th Amendment. But a few things remained, and they have existed and they continue to guide us. Fundamental duties, as I indicated, one part, and another had been this interesting and a significant part which inserted to the Constitution of India, 14A, whereby we have the provisions for administrative tribunals as also the other tribunals, and that the constitutional recognition has gone a long way now, where the tribunals like SESTET have become an integral part of the justice delivery system. This particularly in addressing to the particular areas of concern. Friends, there are challenges, so many. It's right, as Mr. Malhotra indicated, tackling delays, backlogs, speedy justice requirement. In this regard, I wanted to say that in our system, or for that matter, any civic society system, and our country, the glorious country, that we all are proud of our country, the diversities, the vastness of it, with everything being there, well, fraternity lying at the base of everything, and we always go on, we keep on progressing while being together, as Brother Justice Gupta again and again underscored the idea of togetherness. Togetherness is the fundamental filament of our Constitution itself. Now, in this togetherness, in this society, and in this progression, and this marching ahead, there is one feature as we as law professionals remind ourselves always, that legislature, the significant branch of the state, is not only supposed to be giving us law with clarity, law with which could be properly understood and implemented both. There is another feature of this system of parliamentary democracy and the legislations which we have, that the legislature is entitled to experiment also. And this is very significant. And the legislature is not supposed to be giving us always only and only the easiest solutions. There may be typical problems, there may be typical requirements. And addressing those typical requirements, there might be typical laws. And the laws which legislature makes, and that is how the Supreme Court, while dealing with even the constitutional amendments also, underscored way back in Keshwanand Bharti 73, that legislature is entitled to even experiment also. That particular experiment is, well, to address to cater to a particular need or to address to any particular requirement. When it comes to implementation, when it comes to making it sure that the law, even that particular experiment, well, turns out to be, well, fruitful enough for the society, the other branches, the executive and the judiciary, have their unique roles to play. Apart that, the constitutional courts are entitled to even examine the validity of that particular experiment, if I can say so, to examine whether that fits in the scheme of the Constitution or not. If that experiment, well, contradicts the Constitution or it is impermissible, it goes out. But if it is there, that it comes to execution of it, it comes to implementation of it, the executive and the judiciary both have their roles. Judiciary means all tribunals included in that, any adjudicatory mechanism included in that. There we have our responsibilities. We need to, for that matter, when we are talking in particularly with reference to the tribunal, we need to, the executive also needs to remind itself, be sure about what is needed of it, what is required to be done by it, and of course, the tribunal, the court, the adjudicatory process, the mechanism is also to make sure that whatever is expected by this particular law, or if I can say so, experiment, well, that ultimately leads to the society's good. For that matter, so far as the executive branch is concerned, I wanted to underscore a particular factor, and that relates to the litigation policy of the governments. There had been several discussions made when certain recommendations were made for expansion of the judicial infrastructures or from all angles, and different areas were being well attended at. It included the physical infrastructure, the training programs, well, providing for different facilities, even the experiments, something like the morning evening courts also were being discussed. In that process, litigation policies were discussed, and not only discussed, they were put in place. The litigation policies do exist. The point is, particularly for our executive branch, to consciously take note of what is expected of that litigation policy and make it sure that that litigation policy doesn't remain just a matter of letter, but, well, it becomes a lively spirit. When we talk of, well, backlogs or the pendency, this is the efforts, as I was noticing, both the boards, be CBDT or CBIC, they had been giving directions to their field formations also. Well, several of the do's and don'ts, particularly addressing, say, like, well, not going ahead with the litigation having low tax effect. But friends, and particularly the executive as a whole, well, merely doing away with a few of the low tax effect matters will not be yielding those results which we are looking at. There, when we look at our litigation policies, well, we have to make those commitments there and particularly the mandates there, that the government as a whole, in whatever branch, wherever, in whatever manner you are looking at, has to project itself and has to behave and has to deal with the things as a responsible litigant, rather than being a compulsive litigant. These are the expressions I am taking up from your policies only and your commitments only. When we look at the things from an angle where the executive would not be, well, projecting itself or would not be dealing with the things as a compulsive litigant, that, oh, let us leave it ultimately to the tribunal or to the court, the things are going to take a different shape. A responsible litigant doesn't mean that it would simply be curtailing on or simply be avoiding litigation. I would repeat, if it is a civic society, the disputes of the individuals and the dispute with the government are bound to come up. And they had been existing. So far as disputes are concerned, they are integral part of a civic society. And even in the yesteryears, Skatya and Smriti also, if you look at, well, we'll find that even in those years where, as such, the statutory law was not there, but whatever was available from Shrutis and Smritis, the courts of different categories were placed even in those areas where the specialized, well, court systems, specialized justice delivery systems always existed, whether it were the courts of Kul, that is you can equate them with the family courts, where the elders or the learned persons of the family were constituting those Kul courts. There were courts of Shreni courts, where the persons of the same trade were dealing with and settling their disputes. You can equate them with something akin to the arbitral tribunals of the same trade of today. The Gana court, which was the village court, you can equate them with your panchayat courts. And then thereafter, the courts, whether they were Adhikrata court, or they were Shashit courts, or they were Nrap, ultimately the sovereign himself. These categories, every civic system has provided for different categorization of different category of courts, hierarchy also, and, well, different areas of attendance also. So the courts are, the adjudicatory mechanism is an integral part of our society, and well, we have come down a long way now with these specialized courts and tribunals being in place. Sestet is a classic example of that. Coming back to what I was saying, that since the government is the biggest stakeholder, rather than compulsive litigant, if there is an approach of being a responsible litigant, well, the things would take, they have started taking shapes. They would take yet better shapes. For that matter, when we talk of any of the statutes which are in operation and which are dealt with by the tribunal, there are two aspects. A show cause notice, if it has been issued by an adjudicatory body, adjudicatory authority of whatever level it is or whatever name you call it, it's not necessary that a show cause notice, even when a cause is shown, responded to, should always result in an order, well, upholding the show cause notice. There could be reasons, there could be eventualities, there could be possibilities that show cause notice may be required to be withdrawn too. I'm not saying that every case, well, we approach it from the point of view of withdrawing or upholding, because when you start with dealing with a response to the show cause notice by the individual, well, the response has to be neutral to start with, and then if an order is passed which carries its logics and its reasons too, well, the things will start easing better. Simultaneously with when we indicate to the executive that approach should be more of a responsible litigant. When we come to adjudicatory mechanisms, the courts, the tribunals, or any adjudicatory body, here the responsibility and the onus is equally greater and equally serious and equally has to be understood. In the sense that when we have tribunal in place, like great tribunal like Sestet, 40 glorious years we are celebrating today, and I'm sure we'll march better ahead from this time onwards. I'm not indicating about what has been done, including the digitization, well, proper ease of filing also, ease of presentation of the matters also, and the availability of video conferencing facilities. These all are most welcome, these all are needed, these all are our advancements, and we are integrating them with our justice delivery system. As has been rightly indicated, we know it. I was also a party to that development in Allahabad High Court when Brother Justice Dilip Gupta, for all practical purposes, single-handedly dealt with the digitization of the largest High Court of Asia in a very effective manner. I'm very sure this all is being done. Now, proceeding ahead from that, availability of all resources, proceeding ahead from that, there's something seriously needed from all of us, particularly dealing in the tribunal, that when we expect the biggest litigant to be, rather than compulsive, but being a responsible litigant, the decisions in the tribunal are required to be ensured in the manner that the tribunal or the adjudicatory body or the judgment that being delivered is delivered as if it is the last court and as if it is the last recourse, and there won't be anything available further to that. That approach changes, friends, for the reason that when we imbibe those requirements of responsibility, that whatever is being delivered here, well, that may be the last word or the last say. Well, before delivery of the judgment or before asking even a question also, we ask ourselves whether that question is relevant and whether that question is going to lead us to deliver a final verdict, which is final not only in terms of disposal, but in terms of delivery of justice also. So ensuring finality of delivery of justice is a requirement which we need to rededicate these days, these kind of days like the 40th anniversary days. We need to rededicate ourselves that, well, whatever is the decision is being rendered, we assume it to be. And that is what the concept has been. That is how the tribunals have been, well, conceived basically. That these are the specialized, well, tribunals, the special way of doing things, speedy way of doing things. Speed and special, well, should bring about finality. More clarity and more finality and more logic if we provide in our decisions, and that is where when we are dealing with the specialized areas like the subjects which are being dealt with by the tribunal, it was rightly indicated by Brother Justice Verma that, well, it's significant to notice, and it gives an immense sense of satisfaction and a pride to all of us to see that the members drawn from, well, the judicial branch of one side and the executive branch on the other side, they are amalgamated together, and then whatever is delivered. I'm very sure that when we apply ourselves a bit extra as we expect a constitutional court to apply, I'm very sure that a judgment of the tribunal with all its clarity and bringing about finality of the decision making is going to go a long way in reducing the arrears or the backlog as we talk about, because one clearer judgments, well, it's a guiding light not only for the tribunal but even for the executive also, even for the learned members of the bar also to give proper opinions also and the advices also. So that is where, and as we notice, more efforts are being put. We find laborious, industrious judgments being delivered by SESTET, timely decisions also being rendered. What is needed is that, well, experiments are likely to come up. We do not know what tomorrow legislature may give us something more to work at, but we all are capable of, well, dealing with any kind of a dispute or a decision-making requirement which comes to the tribunal. Our efforts continuously have to be that, well, our decisions are delivered in the manner where there is a clarity so far as the stakeholders are concerned, be it the government, be it the individual, and for that matter, well, even when a matter goes to a higher court by way of a statutory appeal or by way of any other mechanism or by way of any other methodology also, at least there is no doubt remaining so far as the logic and the conclusion of the decisions are concerned. I'm sure the learned members of the bar also, when 40 years are being celebrated today, well, they also, when it is being discussed that we need to have continuously the dialogues, continuously the interactions, the specialized areas which are being dealt with by the learned members of the bar, dealing with these subjects before the tribunal, they also need to again and again rekindle their thoughts, to rededicate themselves by way of maybe not only the 40 years commemoration or 40 years anniversary being the celebration of a single day, but joining together. The very many times we have seen the specialized area members, the advisors, in whatever capacity they work, when organizing these kind of seminars, symposiums, where we can, well, interact more, we can discuss more, and after every such discussion, as we have noticed that something better comes out, it gives us new energy also, and new clarity also to, well, help our society to contribute, I would say, to contribute to our society, well, marching ahead with, well, every day being a better day than yesterday, and the today also, when we look at and when we gather, when we discuss, we look for a better tomorrow. So I congratulate the sestet, the land president, all the members, all present here, to be a part of these celebrations. Let us rededicate ourselves to the requirements of the Constitution from all of us. I wish this organizing this particular seminar, as also all other endeavors, all success. Thank you very much having invited me, having given me this opportunity to be with you. Jai Hind.
Thank you very much, sir. It was indeed a matter of great honor for us all to listen to your words of wisdom on this august occasion. May I now request Shri Gurdeep Singh, Chief Commissioner AR, to kindly deliver vote of thanks.
Dignitaries on the dais, our esteemed guests in the audience, ladies and gentlemen. Gratitude is not in the words, but in the heart which expresses it. I stand here today humbled and honored to give expression to our deepest gratitude for gracing us with your precious presence on today's celebration of 40 years of CSTAT. As we celebrate this milestone, let us remember and thank all those who created, nurtured, and worked tirelessly for the past 4 decades to make this institution what it is today. We are extremely thankful to our chief guest, Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, who despite his busy schedule agreed to grace the occasion. We are deeply grateful to you, sir, for your presence today and your kind and inspiring words. Your gracious presence and motivational words will always guide us in achieving higher goals. Your thoughts have provided us a direction and would lead us on path ahead. We are really grateful to our guest of honor, Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, Delhi High Court, for his presence and words of encouragement today. In true sense, he is our mentor for today's function, from making available the venue and infrastructure to ensuring the complete success for the function. Your guidance, support, and benevolence is seen and felt by all of us, the organizers, at each step. Thank you very much, sir. We sincerely thank Honorable Mr. Justice Yashwant Verma, Judge, Delhi High Court, for gracing today's function and for sharing his thoughts on the occasion. Sir, your valuable insight and the inspiring guidance will always motivate us to work harder and strive towards achieving greater success. We are thankful to Honorable Mr. Justice Dilip Gupta, President CSTAT, for conceptualizing, planning, and shaping today's glorious celebration. Sir, your inspirational leadership and vision have been instrumental in making this event a grand success. Thank you very much for your guidance, support, and encouragement. I express our heartfelt thanks to Shri Sanjay Malhotra, Secretary, Department of Revenue, Government of India, for his presence today and his visionary speech. We are aware of rising expectations from us by the Administrative Department of the Government for this tribunal. Your words will always guide us in doing our duties diligently so as to serve the society more efficiently and effectively. We are deeply thankful, grateful to Shri Vivek Johari, Chairman, Central Board of Indirect Taxes and Customs, for his support and encouragement. Sir, your presence today and words of recognition not only give strength to my officers and staff in AR offices across the country, but also help in understanding the core issues in proper perspective. Our special thanks to Shri A.C. Jain, President ECGC Bar Association Delhi, for his presence today and for sharing his thoughts. Your contribution and participation have added value and meaning to this occasion. We are very much thankful and privileged to have senior judges and former judges from the high courts for taking time out of their important engagements to attend this function and bless us with their august presence. We are honored by the presence of presidents and members of other tribunals today. Our sincere gratitude for their unstinted support and encouragement. Members of CSTAT have also traveled from across the country to attend the function, making it a great success. Our heartfelt thanks to them for their benign presence. We are extremely thankful for the presence of members of CBIC on this momentous occasion. Your guidance and support always play a prodigious role in encouraging us. We are honored by your presence today. Principal Chief Commissioners, Commissioners, and other senior officers of CBIC deserve our special thanks for gracing today's function and be part of this historic event. Today's celebration has also provided an occasion to our principal commissioners, and other officers from AR offices across the country to travel and to partake in this institutional interaction. Thank you for your efforts and support. Our sincere thanks to legal luminaries, stalwarts from the legal profession, and advocates for their enthusiastic presence here in large number and for being a part of this joyous occasion. Your support is the key to success not only for this function, but also in our endeavors to serve the nation. This event also brings out a successful marriage between the executive and judicial branches of the state. And no, I am not referring to the spouses of members of CBIC who are members of CSTAT. The success of this function is largely due to teamwork and complete support by CSTAT and its registry officers and staff, along with officer and staff from CCAR office, as well as from zonal offices of Delhi GST and Customs. I am deeply obliged to all of you. We owe gratitude to the management and staff of this auditorium and related infrastructure for so ably supporting us in today's event. Security services and Delhi Police deserve our thanks for helping us. I thank the members of the press and media who are present here. You are our force multipliers in our effort to reach out to public at large. Personnel managing the live streaming of this function also deserve our gratitude. It is through you that I convey our thanks to all our online viewers. As I said in the beginning, gratitude is a feeling which can only be felt in the heart. I would thus say, किस तरह शुक्रिया करूं अल्फाज ही नहीं मिलते, किस तरह शुक्रिया करूं अल्फाज ही नहीं मिलते, ये कामयाबी नहीं मिलती अगर आप सब साथ नहीं देते. Thank you.
धन्यवाद. अब मैं सभागार में उपस्थित सभी गणमान्य व्यक्तियों से अनुरोध करती हूं कि कृपया राष्ट्रगान के लिए खड़े हों.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता. पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा. विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा. तव शुभ नामे जागे, तव शुभ आशीष मांगे. गाहे तव जय गाथा. जन गण मंगलदायक जय हे भारत भाग्य विधाता. जय हे जय हे जय हे जय 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 हे.
All the guests are requested to kindly remain seated till the dignitaries on the dais are moving. Thank you very much.
नहीं होगा. Can tell them now. Yes. वो कुछ नहीं 10 मिनट के लिए ही होगा IT अनाउंस कर लो we'll be breaking for IT now, and my kind request is people can leave in small batches so that everybody is comfortably able to have the IT. And please come back to join us for the first technical session at 12:15. In fact, it's now almost 11:57. So by 12:15, we will have the first technical session. Thank you. Kindly come on the dais. Mr. Lakshmi Kumaran, Mr. Subbarao, and Mr. P.V. Ramanan. You are requested to please come on the dais and take your seats. So yours on the extreme right. Ladies and gentlemen, we are going to have the first technical session for today. The topic is about use of technology in tribunals for speedy delivery of justice. And as you would have observed in the morning during the inaugural session, almost all the speakers laid importance on the aspect of digitization and also how to make use of technology in all the courts, including the tribunals, etc. While considerable efforts are being already taken by the CSTAT and also the CBIC, etc., it is also important to understand as to what are all the further steps that can be taken and how technology and more so the artificial intelligence, etc., can be made use of in the functioning of the tribunal and also in the rendering justice. To discuss this aspect, we have with us today eminent speakers, Honorable Mr. Justice Sanjeev Sachdeva, Judge, Delhi High Court, Mr. P.V. Subbarao, Member Technical CSTAT, Shri Balbir Singh, Additional Solicitor General of India, Shri V. Lakshmi Kumaran, Advocate, and Shri P.R.V. Ramanan, Advocate. Today's panel discussion is going to be moderated by Mr. Lakshmi Kumaran. And before they commence the session, we would like to welcome the guests. May I now request Mr. P.A. Agustian to kindly welcome Honorable Mr. Justice Sanjeev Sachdeva, Judge, High Court of Delhi, with a plant.
धन्यवाद। अब मैं श्री एस गर्ग से अनुरोध करती हूं कि कृपया माननीय न्यायमूर्ति श्री संजीव सचदेवा न्यायाधीश दिल्ली उच्च न्यायालय को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
I now request Mr. Abhishek Jaju to please welcome Mr. P.V. Subbarao, Member Technical, with a plant.
धन्यवाद। अब मैं श्री एस थिरुमलाई से अनुरोध करती हूं कि कृपया श्री पी सुब्बाराव सदस्य तकनीकी को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Bipin Garg to please welcome Mr. Balbir Singh, Additional Solicitor General, with a plant.
धन्यवाद। अब मैं श्री प्रकाश शाह से अनुरोध करती हूं कि कृपया श्री बलबीर सिंह, एडिशनल सॉलिसिटर जनरल को कृपया स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. B. Venugopal to kindly welcome Mr. V. Lakshmi Kumaran with a plant. उधर से
धन्यवाद। अब मैं श्री MS नागराज से अनुरोध करती हूँ कि कृपया श्री V लक्ष्मी कुमारन को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
I now request Mr. Rajesh Chibar to kindly welcome Mr. PRV Ramanan with a plant. ये आप कर लीजिए।
धन्यवाद। अब मैं श्री राकेश कुमार से अनुरोध करती हूँ कि कृपया वो श्री PVR रमनन को स्मृति चिन्ह भेंट करें और उनका स्वागत करें। For our first technical session, in our esteemed panel, we are having Honorable Mr. Justice Sanjeev Sachdeva, Judge, High Court of Delhi. Mr. Sanjeev Sachdeva got a Bachelor's of Law degree in 1988 from Campus Law Center, University of Delhi. He was designated as Senior Advocate by High Court of Delhi in 2011, elevated as Additional Judge of High Court in Delhi in 2013, and as a Permanent Judge in 2015. Justice Sachdeva is a part of Information Technology Committee of Delhi High Court. Delhi High Court was one of the first to commence virtual hearing during lockdown and to start the process of online filing, scrutiny of file by registry, and clearing defects through the portal online. In his tenure as a High Court judge, Justice Sachdeva has been a part of various rosters and decided landmark cases related to taxation, human rights, and commercial laws. He has been the part of several tax benches with Justice B.D. Ahmed, Justice Sanjeev Khanna, and Justice Ravindra Bhatt, which rendered many landmark judgments. Justice Sachdeva has time and again struck a delicate balance in issues related to human rights and fundamental rights, which very well reflects in his judgment. Sir, we welcome you in the first session.
We also have, as one of the speakers, Mr. P.V. Subbarao, Member Technical at CSTAT. Mr. Subbarao was appointed as Member Technical at CSTAT in the year 2018, and he has wide and varied experience as an officer of the Indian Revenue Service in the Customs and Central Exchange Department. Prior to his becoming Member Technical at CSTAT, he functioned in various capacities as a Director Narcotics Control, Additional Commissioner of Customs, then Commissioner of Customs handling the Tuticorin port, which was one of the heavy traffic ports in India, handling textiles and garments. He was also the Joint Secretary, Coffee Posa, Central Economic Intelligence Bureau, Preventive Detention of Smugglers. He has authored very many judgments in the last 5 years on complex service tax, customs, and central excise issues involving classification, taxability, interpretation of notifications, etc. He is also playing a key role in the entire digitization process, which is currently underway in CSTAT. We kindly welcome Mr. Subbarao for this session. We also have amongst us Mr. Balbir Singh, Additional Solicitor General of India, Supreme Court. Mr. Balbir Singh is one of the youngest lawyers to be designated as a senior advocate by the Delhi High Court in 2015. He set up his own firm in 1998 and started his practice as an indirect tax lawyer in CSTAT. In later years, he branched out his practice to several other areas of law apart from tax. He has extensively worked on corporate and tax structuring for large multi-jurisdictional companies. He is one of the few lawyers in the country who have excelled in such different areas of the legal practice. He is a senior standing counsel for Income Tax Department before the High Court of Delhi, and also a standing counsel for the Competition Commission of India. The assistance provided to the court by Mr. Balbir Singh as a senior standing counsel has set the benchmark for others to follow. In June 2020, Mr. Balbir Singh was appointed as the Additional Solicitor General of India. In his tenure as an ASG, Mr. Singh has immensely contributed to the tax jurisprudence. We welcome Mr. Balbir Singh.
Our next eminent panelist is Mr. V. Lakshmi Kumaran, advocate. Mr. V. Lakshmi Kumaran, managing partner of Lakshmi Kumaran and Siddharan, is a leading litigating lawyer in India. He specializes in direct tax and indirect taxes. He is an expert in handling cross-border transactions, valuation of goods and transaction between affiliates, transfer pricing, international taxation, international trade laws, covering WTO laws, trade remedies such as anti-dumping, countervailing duties, and safeguard, foreign trade policies, etc. He has rich experience in commercial litigation, arbitration, intellectual property laws, competition law, corporate law, including food safety law and environmental laws. His deep understanding of technological issues that impact taxation, as well as his expertise in classification of goods under HSN, are highly recognized. Mr. Lakshmi Kumaran represents clients before various adjudicating authorities, tribunals, high courts, and Supreme Court of India. He has also represented clients in other jurisdictions like European Union, USA, Australia, Canada, etc. in trade remedy cases. He is also advising the Government of India, Ministry of Commerce, and various free trade agreement negotiations. Sir, we welcome you in today's session.
Mr. P.R.V. Ramanan is another speaker for this session. Mr. Ramanan, an officer from the Indian Revenue Service, was member Central Board of Excise and Customs. During his stint at the CBEC, as it was then called, Mr. Ramanan has also been on several government committees and expert groups, and even today he continues to advise the Government of India. He was a part of the Technical Committee on Customs Valuation of the World Customs Organization from 1995 to 1997. In his second innings, Mr. Ramanan appears as Special Counsel for the Tax Department in many high revenue cases before the different benches of CSTAT. He has appeared in cases such as relating to valuation of goods, customs valuation, leviability of tax on activities of a trust managing funds on behalf of contributors, etc. We welcome Mr. P.R.V. Ramanan. Now it's over to the panelists for the discussion on the subject. Thank you.
Thank you, Narasimhan. I do the job of the moderator. Very rarely I get an occasion to sit on the same side of the judges, honorable judges, and the members here. I always on the other side to argue the case I'm addressing in my lords. So for the first time, I think I'm going to be on the same side. What we intend to do is, one thing you had mentioned, Mr. Ramanan was the person who was in TRU, who was also a member of the JHA committee report, and who actually drafted the legislation for the CSTAT, at the come to CGAT. And I was the person assisting him during that time in TRU. So I thought I should mention him specifically. He's my guru, and he actually did the legislation for the CGAT at that point of time. Sir, I think what we should do is, without wasting any time, my Lord Justice, you can make a presentation in the beginning. What we intend to do, sir, others, if you want to make presentations, which I can do. Otherwise, for the first time, I'll ask questions on how you intend to bring this particular technology into the justice portion. Always been on the other side, answering questions from the bench. Once in a while, I get an opportunity to ask the question to the bench.
Are you appearing in High Court tomorrow?
Tomorrow is Sunday, huh?
That's a conscious question.
No, I am conscious. Yes, Monday I do appear, sir, but I think you will not have any grudge against me on that point. Good luck. Yes, sir.
Can we have the presentation on the screen, please? You see, normally, when I begin with this kind of a session, I do a lot of these technical sessions on technology. Let me tell you something. I've been a judge for about 10 years now, and I've never used paper. In 10 years, all the jurisdictions that I sit in are digitized. There is no paper used from filing to digital signing of orders, checking of orders. Luckily, Delhi High Court started digitization in 2008, 2009, I joined in 2013, and as a lawyer, I used to bring laptop to court. I still remember a stage when 11 or 12, Supreme Court banned laptops in this court. They said you will not bring in, because the only reason was that when a query was put by the judge, the lawyer would open up his laptop and start searching there for a judgment. So that was something which led Supreme Court to say, please don't bring your laptops, because you're not doing your research at home. You're doing, when we raise a query, your junior is sitting there and now typing up and giving you a judgment. You're citing it without reading it. But now we've come to a complete change where we want technology. And especially when I see a mix of audience, I see the backbenchers, as we call them. There are a lot of backbenchers here who are complete youngsters and who are actually expert in technology. We all grew up, we didn't know what technology was. Those backbenchers actually were born with the laptop and with a tablet in their hand. So what I'm going to do is take you for a walk in history. And this is especially for the backbenchers. And normally when I when I started giving these lectures 10 years ago, I used to ask, how many of you use a smartphone? Now that question has completely changed. How many of you do not possess a smartphone? Anybody here? Well, the most tech-savvy person will never carry a smartphone. There are several reasons for it, but let's take you for a walk through history. The youngsters won't even know what this is. Has any one of you seen what this is? This was a black and white TV. Well, this question is not for the front. This is for the children at the back. This was a TV we used to have. This was black and white. Imagine a black and white TV. And we used to have, for entertainment, half an hour on Wednesday, half an hour on Friday, and a movie on Sunday. Half an hour on Friday, Wednesday used to be Chitrahar, where we'll have movies. And you will not believe it how many hours we've spent watching Krishi Darshan.
And that Doordarshan sign, that's the
Doordarshan
logo
sign.
used to come.
This used to be a radio set. And the technical ones could actually tune it and hear something other. There'll always be a crackle sound. And this is something which I doubt if you people would know. And half of you will not know what is the connection between a pencil and a cassette. And then we had cameras like this. Now we take selfies. The cell phone people carry it. You take thousands of selfies. We used to have a roll which would give, initially it started with a 12 film, then became 24, then the final was 36. And the experts could take out about 38, 39 prints out of that roll. And you could not see a print till it was developed, and suddenly you realize that everything's gone. And the best part was the experts would take out the roll and roll it back, and then realize that everything washed out because light would destroy it completely. This is how we started playing, not the video games, but we started playing with things like this. And this is how the laptop grew. We had 1984, 83, I still remember the laptops were introduced. The desktops were introduced. We didn't have a hard disk in a desktop. We had a floppy drive. The operating system was a floppy drive. The program was a floppy drive. And this is what is something like, you know, that's right, our ancestors had tails. This was their ancestor. And if I give it to some of you, I'm sure you won't be able to know how to dial a phone. How does this work? Some of you will not even know how do you dial a number. Then these boxes, STD, ISD, PCO booths were there. Some of you won't even know what they are for. And you see the device on the left is called a pager. How many of you don't know what a pager is? Well, you all know, you're tech savvy. Anyways, the pagers came in and were washed out in few months. Because at the time when pagers came in 1996, the cell phones didn't have messaging service. So pagers came in, messaging service was introduced in cell phones, and pagers were then off the screen. This is how cell phones grew. The first one in 1985 was as heavy as a brick. I still remember I had the fourth one from the left, and no, the one's not here. Anyways, now you all must be wondering, how is this relevant? How many of you know what a RAM is or what a megabyte is? You see, now this is something for the ones on front. Computers don't understand characters. It understands electrical impulses. 0 means electricity off, 1 means electricity on. So 1 0 and 1 1 is called a bit. byte is a combination of zeros and ones. So characters are represented in bytes. So when we talk of kilobyte, it's 1028 bytes. Then megabyte, 1028 kilobyte make a megabyte, and 1028 megabyte is a gigabyte. We go and buy a cell phone, we say we want 16 gig RAM, so much storage. Now, what does that mean? This is a 6 GB RAM, this is I think 2013 or something. 20th July 1969, the famous words were spoken, Eagle has landed. I'm not talking about the Jack Higgins novel, The Eagle Has Landed, or the World War II movie, Eagle Has Landed. These were the words man spoke for the first time on the moon, Neil Armstrong. Eagle has landed. You must be wondering, how is this relevant? This is relevant to show you the graph of what technology has reached and where we have reached. Apollo 11 was the spacecraft which landed on the moon and brought Neil Armstrong back. Had a computer which was 1300 times slower than an iPhone 5S. Today we are waiting for the launch of iPhone 15. You know how much RAM was there? It had a RAM of 4 kilobytes. We are talking of megabytes, gigabytes. We have our phones have RAMs of 16 gigabyte. So imagine each one of you sitting here in this room can take about 100,000 Apollo 11s to the moon and bring them back. That's the power you have in your hand. That's where the world has reached. The world has moved on. But what about courts and tribunals? We take so much pride. We are a progressive society. This is not only for India. And let me tell you, Indian courts are far ahead in terms of technology than the entire world. They may claim to be far ahead, but they're not. When I gave a presentation to some of the technical team from England, they were actually shocked that you've been able to achieve that. Now they want to partner with us so that we can bring their technology level, their courts to the level that we have reached. We are far ahead. But are we far ahead in terms of how the technology has gone? So where have we reached? This used to be the typewriter we had when we started practice. And this was a typewriter which was there from the very beginning. We migrated onto a dot matrix printer, an inkjet printer, and maybe then a laser printer. That's all. This was a printout which used to come out of a this was from a Remington typewriter. And we had to use something called a carbon paper. Do you know what this is? The youngsters at the back, do you know what this is? Now, you had to, when there were no photocopy machines, I still remember I had to submit a paper in when I was studying in graduation. So a photocopy machine used to be one big camera, and there'll be a slide. He would put a paper on it, he'll take a photograph and then shake some powder on it, and will take about 4 minutes for one page to be printed. No photocopies. So the typewriters, carbon paper used to be, we used to print 1+3. And the opponent would always get the 4th copy. And God forbid if he had to make photocopies out of that. It used to make troubles. Now the courts have transformed from this to something like this. Now from this to this. Now that is the level where technology can take us. And for us, the lockdown showed us that we could go paperless. Luckily for Delhi High Court, we went paperless in 2008. This is the photograph of a real courtroom. Again, now in the court, we are developing a system for the lawyers. So you don't need to bring in your file. The file will be there for you to see. Come in with your notes. The file is there. Argue from the court file. You don't need to carry in. Just bring your laptop, iPad, or a piece of paper where your notes are, and the entire file is there available to you in the digital file, which replicates exactly as the court file. So just open it and argue. Now this was a hybrid hearing. Luckily, you see, one more information I'll give you. When lockdown happened in 2020, Delhi High Court was not shut for a single day. Lockdown was imposed. We all locked down in our homes, but we could operate. We had to change some systems. We had to change the filing system. We would accept petitions on email. Lucky for us, we had systems in place and all the judges were operating from their homes. Not a single judge took off, everybody was operating from home. This is actually a photograph of 2018, I think. Before the lockdown, I had tested a hybrid system in court. One of the officers couldn't reach the court, so we tested a hybrid system. And you see, I'm using a tablet. We call a Wacom screen. And the person was connected through VC, and you can see the screens which are there for the lawyers. So the person connected through VC, and we had a hybrid system, hybrid hearing. And then lockdown showed us a virtual hearing. We migrated onto it. An empowered judge would be in a position to dispense speedy justice. We are all talking of introducing technology. There are several stakeholders. Now, technology can reduce processing time, expedite transfer of file, reduced on site storage of files. We don't know how many square feet of space we freed up in the High Court by digitizing record. Improved access to justice, availability of orders online, overall increase in efficiency. This is the screen. You see, what happens is there is really a mental block. Will I be able to adapt to technology? Will I be able to operate in court a digital system? That's the first fear a judge has. And I'm very candid in this when I say this, and I say this to every judge. You see, the greatest fear, I've spent 25 years as a lawyer, 10 years as a judge, and you give me a new system, and I'm not even able to open it in front of youngsters like them who are tech savvy. Am I not going to feel embarrassed? That's the simplest reason why somebody says, look, no, I don't want to use technology because I might get stuck in court. What would everybody else think, that I don't know how to operate a computer? Well, we have a solution for the judges. What we have done is, this is the Wacom screen, the judge's screen, where you can see on the left is the cause list, center is the case file, and the right are the notes. This is also parallelly, it can be connected to the court staff or a technical person sitting there. So he would operate his computer, and if the lawyer says come to page 54, he will change it to page 54, and the judge, in front of the judge, there will be page 54. He doesn't have to do something, he doesn't even have to open a file, and there is somebody operating the system for him parallelly, and it can work. Like this screen is duplicate from here. So I can maneuver here and the judge can see. You can see what is happening. I'm maneuvering it. So that's a solution we've given to the judges. A digital court file. Another issue is, look, we are used to a particular file system. A particular file which is broken into different folders. Best thing about technology is you can adapt it, change it to your needs. You don't have to change for technology. If you are used to a particular file, how a file looks like, every tribunal, every court has a different file format. Well, a digital file can be adapted to look exactly as you want to. It's stored in PDF format. We don't use any software. We only use Adobe Acrobat, which is available online for free to download on your cell phone, on your device, any tablet or your computer. We use it in that format, and it is broken into portfolios. We are used to separate files like a file orders folder, an application folder, or a pleadings folder, evidence folder. So file is broken into different folders. This is what a sample of a writ petition record looks like on a screen. You have different folders. On the right is an appeal folder where you have the lower court record also there. Now this is a suit record where you have evidence. So you can adapt it to look like anything. Once it is open, now this is again a screenshot of the tablet that we have. On the left, if you see, this is the notes that I have on my screen. Sometimes people wonder that without opening the file, how do I know which application number what? This is the benefit of technology. On the left, if you see, there is the blue highlight is the case number. I click on it, the file will open. On the left is the application number. This is a trade secret I'm disclosing. I don't know how many judges would like that, but in any case. On the left, you see these are applications, like there is leave, the first you see leave to file lengthy list of dates, service of respondent number 3, report awaited. On delay in filing 63 days, stay, execution. On the right are the small notes that I've made one day before as to what this case is about. So I don't even need to open the file. I know service is complete, not complete, in seconds. Nobody needs to hand over the file. I click, I look at the cause list, service is not complete, all right, issue notice to so-and-so person is not served. Matter over, out of the court. I remember I was sitting on a vacation bench. In vacations, we don't have, since the filing happens till very late, we can't digitize the record. So a whole lot of cases come in Basta. I had about 90 cases that day, and I said, let me time it as to how much time I was spending reading a physical file. So the timing I was doing was picking out the file from the Basta, opening the thread, closing the thread and putting it back was taking me 1.5 minutes per file. So 90 into 1.5 minutes was the time I was spending at home a day prior, just doing that manual work of opening and closing. In a digital record, click of a button, we all know, click of a button, go to the next, click of a button, go to the next. And if I have a report like this, I don't even need to look at that file. But in a physical file, I have to actually open it, see what is the service, go to the service report, check it and do it. Our court staff, LRs, the court masters, etc., they prepare this note for you. Now this is how an open court file looks like. You have a case file with OneNote. OneNote is a feature again of Microsoft. You can make notes on it by handwritten notes. Anything you can do, you want to do it, no issues. Again, you can highlight. Now in a physical file, you can't highlight it. At least judges can't, because that's original record. We can't tamper with the original record. You can underline, you can make a note on the file. And by just clicking on the bookmark, the files are all indexed. Now we are used to those flags on the side. Now I will flag, supposing the flag goes away. Now we have the files which are indexed. You click on a particular bookmark, that page will open. Now you click on a comment, that particular comment will open. If you have underlined something, on the right side there will be a comment list. That the matter is, as counsels, if you wish to argue a matter, you want to draw the attention of the judge to a particular page, just highlight it, click on it and it reaches that page. That's why sometimes using a digital file, we are far faster than what a lawyer can be with a physical file. You can copy text. This is a feature of OneNote. You can copy the entire, you can clip the page. Now this is one feature that I use extensively. When lawyers are arguing, you see, sometimes matter go on for hours. So I would take a clip, capture a screenshot of that page which is shown. For example, it's a show cause notice issued. So I just capture that show cause notice or that page, that particular issue, and then lawyer takes me to the reply to the show cause notice, go to that page, clip it, and it all comes on my OneNote. When I'm dictating a judgment, I don't open the file. I just look at the OneNote. All the documents are there extracted. With your notes, supposing a thought comes to your mind, seeing a show cause notice or a reply or a pleading, you make a note on the side in OneNote. It's there for you. Now you can simultaneously open two files which you can't do, 2 pages which you can't do in a physical file. Office notings, now staff sometimes prepares an office noting. These can also be available digitally, otherwise you have to again open the file. These are some of the benefits. Now again, for the court, we have something called a parcha entry. Now when the date is fixed, I don't know, in Sestat, do you give a fixed date? Or if it's a fixed date, then there is a feature like this where the court staff who is giving a date has a calendar on his desktop with the number of cases, the number of cases on that day. If you click on that, you can zero down to the kind of cases which are listed, whether they're for hearing, whether they're for completion of pleadings, etc. So all this can be managed within seconds. Now again, how do you digitize record? Now we have an e-filing. In Delhi High Court, there is no paper filed. No paper is accepted by the registry and is e-filing. Now question came to our mind, how do you make the lawyers change? We want digital file. A lawyer says, look, I don't have the wherewithal to digitize a record and file it. You want a digital file, we can't help it. I'm not going to set up a full computer system for digitizing the record. But we've made e-filing compulsory. So we came up with an idea that every court has a scanning agency which scans their records. So we called the scanning guy, we told him, look, you set up a counter at the filing counter and charge them 10 paise per page extra. We give him, I think, like 60 paise, he charges them 70 paise or 75 paise per page. Photocopy costs more. The lawyer brings his physical file to that person. That person counts the number of pages, gives him a receipt of that amount, and he comes to the filing counter and files it. He's done nothing more, not even got a photocopy done. That filing counter person takes it, gives it to the scanning guy, he scans it, makes a portfolio as we need it. So that's added advantage to us, and gives him back the file with a pen drive. That person goes to the filing counter and files the pen drive. Now, how easy it is to file is something we'll just show you. Again, when you file digitally, you need e-court fees. Stockholding gives you that feature of purchasing court fees online. Now, this is the filing. This is actual filing happening. You go and select the case. All right, I'll start it again. This is going too fast. Now, person goes, he says it's a main case filing. He browses, he goes to, we have a system called, you see, sometimes you have to type the memo of parties. So the moment he clicks on memo of parties, the entire fields in memo of parties are automatically picked up by the system and uploaded. Then he's gone and selects the case category, the subcategory. He is now uploading the court fees. Court fees is a 16-digit number. So he uploads that number, adds the court fees, and uploads the document. The filing is complete. It's only this much time it takes in digital filing. In physical filing, your clerk would be standing in queue waiting for his turn, and the court staff also doesn't have to do anything because the court staff is entering the memo of parties, but all this is done real time. And you can do it 24/7 sitting anywhere in the world. Then the cases are scrutinized online. Again, this is a feature for the registry. They can, once there is a defect, immediately a lawyer is informed there's a defect, cure the defect. Once the defect is cured, it's taken into portfolio if it's not already then, uploaded to the court, and the entire information about how the file has traveled is digitally stored till it's listed. And an SMS is sent to a lawyer, your file is under objection, cleared, or is listed on so-and-so date. All that message can be sent. Even an SMS-based system where lawyer wants to know, or litigant wants to know what is the stage of his case, he can send a push-based system and he gets the entire information. End step is again something which the Supreme Court has started. It's a centralized process serving system. Now, how many of you have used Amazon? Nobody's used Amazon. Again, wrong question. How many of you have not used Amazon? Anyways, you see, when we place an order on Amazon, it tells it exactly when the parcel is going to be delivered. And it is delivered. Now, if you raise a query, they'll promptly send you a photograph of the signature of the person who's received it. That is something which the Supreme Court is now trying to do. There'll be handheld devices. People will go and capture the geo coordinates of delivery of that summons. And immediately from that device itself, it is uploaded onto the court system. So a judge will know real time whether summons have been served or not, because in court, several times we have to adjourn matters, service report awaited. Here, this is one thing which is again an exceptional step which the Supreme Court is doing. Then, when the case is filed, an electronic file, we have the entire case history captured. Case history is something like this which gives every detail about what has happened in the case. Anything filed, an application filed, document filed, returned under objection, court orders, everything is uploaded. E-inspection is again something which was inaugurated here in this hall on 24th January 2023 by Honorable the Chief Justice of India. What does e-inspection entail? You see, we all, especially young lawyers, have inspected records. You make an application, you want to inspect the court record. Now what system we have brought in place is that soft copy of the entire court file will be provided to you. You give an email, make an application subject to whatever the rules are. It is checked, file is uploaded for 48 hours on a portal, download that file and you have a complete record available with you of the entire court file. Again, there is a dashboard for judges who provide information to them, which was a whole lot of information. This is again technology which the tribunal can use, information which is available, required. Another benefit of technology, which is something which I extensively use even today, is this. record your arguments. If arguments are taking place in court,
where 31 megawatt is allocated by the central government, it is 35 years old.
now when an argument is happening, record it. When you have to dictate a judgment, revisit it. So simple. Otherwise you have to, because sometimes you see longish arguments, matter was heard 15 days back, again part heard, and another argument happening now and spread over 5 or 6 hearings. Judges may remember, may not remember, you have your notes, but sometimes applications come, I argued this is not there. If you have a recording, just hear it. And the recording will also capture the questions which are posed by the judge. So all that is available. The thought which came to your mind at that time is also reproduced because you put a question. So this is a major benefit of technology. There's a judgment portal, again Supreme Court has started that, where judgments can be available online. Now question is it not time to move on to something more dynamic? We have still to achieve this, artificial intelligence. Now AI is not alien technology. We use it every day. It's actually used on us by the corporate houses. It's all around us. Now again, AI is something again which is a major topic. It's probably a full session, but briefly I'll touch upon what some other courts are doing. Brazilian Supreme Court is using document analysis and natural language learning processing to track resources that deal with issues of general repercussions. Then similarly, US courts uses Compass. Now a word of caution. AI has its pros and major cons also. So it's not there at the moment to replace us. There is recently a robo lawyer was there, and then the Bar Association came up with the plea in US and then sued the lawyer for practicing without a license. So all that fallouts will be there. Now again, these are technology which is being used by several courts abroad. Now this is one on the lighter side. His decisions aren't any better than yours, but they are way faster. And again, AI services, Supreme Court has started Suvas, which is a translation software. Then it uses Supace, which is a tool which is made available to judges. Then recently it was launched, that real-time live transcription using artificial intelligence. Now, AI can improve existing infrastructure, but again, like I said, this is a full topic. Now, again, on the lighter side, would you like to install a new Supreme Court justice? This is US, in fact, I don't mean, or upgrade the existing one. Well, Steve Jobs said, people who are crazy enough to think they can change the world are the ones who actually do. Thank you.
Thank you, sir. I think inspired not only the backbenchers, including the front ones. Thank you very much. I think, Mr. Subbarao, you want a presentation or you would have some questions?
I don't have a presentation. I can just briefly as to what is the status in SysTed.
Yes.
What is this? Yes.
Thank you. When I was asked to be part of this session, so I asked Honorable President, he said, "मैं क्या करूँगा उसमें? You have luminaries, you have Judge of Delhi High Court and your Additional Solicitor General of India and Mr. Lakshmi Kumaran, and of course Mr. P.R.V. Ramanan. Mr. Lakshmi Kumaran is the most well-known face in the field of indirect taxes litigation. And Mr. P.R.V. Ramanan is probably the senior most IRS officer attending this conference today. In fact, I would relate to him like this. He joined IRS 2 years before I joined my LKG. That is, so President has told me, look, the reason I put you in here is you are dealing with this matter, so you are the best person to brief what is happening in SysTed. So that is the role. So that's what I propose to do. In the morning, we had some discussion about the how we overcame the problem of shortage of members and overcame the problem of COVID. Of course, there was a severe shortage of members at one point of time, not more than 4 technical members, so we couldn't constitute more than 4 benches at that time. And of course, the recruitment took time, as it normally does. But until the recruitment process was complete, we had to find a temporary solution. And that temporary solution to this crisis came from another crisis, which is COVID. So which forced us to go digital. Until then, there was no e-hearing or before in the SESTAT, so we started having e-hearings. The advantage of that was the same bench which was hearing same bench of 2 members, which was hearing appeals, say, from Delhi in the morning, would hear appeals in the afternoon for Chandigarh. And next week we'll have Delhi bench in the morning and afternoon bench will be for Hyderabad. That was beautiful. It worked quite well. The only problem was that while our hearings were all digital, our files were all physical, and they're still physical. Now we need to move beyond that. And this created a very unevenness in our system, because if the hearings have to take place by the members sitting in Delhi, has to hear matters which actually pertain to Allahabad or Hyderabad, the entire file, case records had to be literally mailed and posted and brought them here. And it created another asymmetry in the use of court resources, courtmaster resources, because the courtmaster in Hyderabad would then be sitting idle, whereas the courtmaster in Delhi had to deal with various benches matters. He had to open and manage each file and then send them back to the respective benches, or if it is adjourned, he had to hold them for some more time, keep track of them, and then decide when they have to send back. So in court number 3 of the SESTAT, once during the COVID, I went, when we were all having e-hearings, I went in to talk to the courtmaster. Then it was like Delhi heart. He says, sir, this is Delhi, this is Chandigarh, this is Hyderabad, this is Chandigarh. So Sara Bharat Darshan karwa diya, and the courtmaster in the last 5 minutes. So that problem basically was we are trying to sail in 2 boats at the same time, with 1 foot in the digital boat, 1 foot in the physical boat. And the job of the staff is to keep both of them together. Now, to overcome that problem, of course, we no longer have the problem of shortage of manpower, of the members. All the members have been filled up. Posts have been filled up. Now that comes, what are we doing to move digital this thing? When SESTAT was started, of course, we started with the Remington typewriters and the appeals. Then we developed the case information system, which is basically mentioning the basic information about the case. As soon as the appeal is filed, somebody sitting in the registry would type out the basic information about the appellant, respondent, their address and numbers. This is all our registry. Cause lists are generated by this. Case proceeding reports are generated by this. But that file does not cover the complete case. It doesn't cover the statement of facts, it doesn't cover the arguments, it doesn't cover the attachments. You only have the basic information. So that based on that information, you can do very limited amount of exercise can be done with that. Added to that, we actually had these servers, 1 server in each of the 11 locations we have in SESTAT, that is one in Delhi, one in Bombay, etc. In each place we have. So the information which is available was there in different benches, different servers of different benches. It was not put together. So if you wanted to know what is happening, you have to actually put all these things together. So we have 1 server for each of those benches. We still have 1 server for each of the locations. Then we have another server of the NIC server where we maintain our website. So what happens is at the end of every week, we get all the people sitting in the NIC people who are on deputation who work in SESTAT Delhi, they get all the details of the information from various servers, bring it all together, put them, and then they upload it onto the SESTAT website also. That's how we come to see the website, and we get the information together in that. So this was discussed, and we developed a project with the NIC as to how to modernize this system. In short, what the NIC suggested is just move everything into the cloud. everything be served on, put on one single server, as it has been done in the customs. Those from the customs would know, earlier we used to have a server in each custom house. Now we have a single server at Delhi which manages all the customs transactions across the country. So we'll have a single server here in Delhi in which all the data can be transferred. Then the case information system and software for that has been developed by NIC for us. This has been tested, and then it went through security audit. It has been launched. And all the past case information system, whatever is there in all these servers, has been migrated into the new server. And the new information which is now being typed is still being typed by various benches. It gets directly typed onto the cloud. It is no longer in the local server. So gradually the local servers will no longer be useful. So to that extent, we have operationalized that. The second part of it is, of course, the e-filing module, which is the final solution to this. Once we have an e-filing, the entire file, including as Delhi High Court is managing, all the files, everything will be available for this. Accessible directly, a soft copy of everything will be available on the system itself. Software for this has also been developed by NIC using their experience in developing it for Delhi High Court and other places. This has been sent out for user tests. This has been tested by both the members of bar of various benches and also the departmental officers of various benches. And then they gave some feedback, some changes they wanted. Those have been communicated to the NIC. NIC is working on them. As we speak, they are working on them. Over the next couple of weeks, probably they'll be able to make all those changes. Once those changes are over, the software will have to go through the security audit, and then they would launch. So now then, thereafter, probably we'll have an e-filing system, and then, of course, the things will start moving seamlessly, and due course will stop the physical filing completely. The only question will be the past records. Past records will continue to be physical. That's what one thing, because the records as we find are the files which, at least what we get in SESTAT, are not in, don't have to count in number of pages, it's more in inches and feet. That's all. So these are quite bulky, and what to do with the old records is one thing. Either they get disposed of or old cases, but the new cases at least will get filed in time. The advantage, of course, of e-filing is also that the question of service and the question of issuing notice, the question of informing when there's a meeting, when there's a matter is next listed or something is adjourned, these things have been automated in the system as it has been drafted. So the moment a person files, whether it's the department or the SSC files an appeal, he also has to mention the email ID and phone number of the other party. And as soon as the filing is complete, a notice will go to the other party that an appeal has been filed. Similarly, when a meeting is, an hearing is held or it has been adjourned, all notices go automatically. This is served to the extent which we have completed. The last part of what we are trying to do is to revamp the website. The existing website, although we call it SESTAT New, is pretty old as on today. And the new, it doesn't meet the Government of India guidelines for websites. A new website which is compliant with this and which will meet all these requirements of the Government of India guidelines is being developed by NIC as we speak. Once it happens, all these things will get seamlessly integrated. Another initiative, not by us, but initiative by the Supreme Court, which we have been able to implement, is the Ministry of Law, along with NIC, has developed a legal information management and briefing systems called the LIMS. This, the intention, the purpose of this LIMS is to ensure that the status of case of a particular case in various courts is integrated together where government is one of the parties. So our commissionerates, through this Chief Commissioner AR's office, we convince the commissioners to put all their data, all the data pertaining to appeals has been loaded. And from the SESTAT side, we have ported all the data which are the current status of any appeal, any order which has passed. With respect to those appeals, we ported on the LIMS. The information is now available online for any field office to see. And actually, once we move on to the cloud, this porting will also be automatic. We don't need anybody to do it systematically. This is where we stand at present. Yes, sir. Thank you.
We can be there. I'll. So a few questions to you, sir, before the next speakers back. You mentioned about the past records getting converted to digitized. That is a big problem. How do you intend to solve it? Can we just ask the concerned attorneys to file a revised digital copy now, and that can become the record for you?
One thing we need to think about, because it's the thing, otherwise you will still be in the part, half the files will be physical, half the files will be digital. We will still know. We won't be able to reach that level.
And secondly, sir, unlike in the Delhi High Court, I think you have 11 benches, different places, etc.
Yeah.
The file coming, going back, a physical file always a problem. Once it is digitized, I think there is no difficulty. The more important thing which I have a question to you, sir, is many of the matters in the CSTAT are similar matters, more or less identical, but it may be in Bangalore or in Kochi or in Delhi, other places. Once you digitize all the records, is it not possible for us to do the AI, which Sir said, to list out all those cases which are similar items or questions, and list them together and then dispose it off, and then people from anywhere, they can argue the case, no difficulty. In one go, I think probably you can dispose of 30, 40, 100 appeals, etc. That is where I think we can use the analytics, the next stage, because once you have the information, and once you start analyzing the information, and that information can be used for the whole item is how do we do the speedy justice. If we can have that information, and then you can issue a common notice, and then ask people to appear, give the ration the time, because lawyers normally take longer time, etc. You know how to control them. Sir knows differently. So once you put that, and then they let them fill the written presentations, etc., in digitized form, and give them 5-10 minutes ration time, etc. Highlight to be highlighted. But you can dispose of hundreds of matters on similar matters, etc. Just a thought process, sir. You can reaction.
That's an excellent idea. We actually, not across country benches, but within the bench, I tried doing that, but the way our information structures as on today did not help the system. Because the question of law, whether some, say, moderate credit can be allowed in a particular case, those questions are not part of the fields. What the field as on today, what we have is either somebody has to physically read it and understand it. And the registry was also not able to help it. So, otherwise, where a particular question was already settled. So I would ask the registry, okay, do you have any other cases which have similar issue? They say, sorry, we don't know.
Sir, suppose we help you in creating various fields, and the system is fed into that, then it becomes easier for you.
You see, may I answer this? Yes, sir. Brazil is actually using this software. They're using AI technology to scan the records and find out which are identical cases. And not only tribunals, why can't it be done across the courts, across the high courts?
Even the research.
Because several times happens, one issue pending before Delhi, another before Bombay, Calcutta, Madras. And I gave this suggestion at one point of time in a judicial academy, that we can today develop an expert bench on because you see, everybody may not be expert in a particular field. We have one judge in the High Court who's an expert in, say, taxation matters, and another judge in Bombay who's an expert in taxation matter. And you have a division bench sitting from remote locations for that matter, and that's settled once and for all, and they can take up all cases across the country which are identical. And even for that matter, sometimes what happens, you have one jurisdiction, for example, say a smaller court, where there isn't enough work. So you can pull in that judge, all right, you hear this matter listed in Delhi, a criminal matter or a tax matter or a civil matter, while you're sitting in, say, for example, Imphal. Imphal, he can hear, the lawyers can appear virtually, the judge can hear virtually, digital file can be shared, and matters disposed of. So we have sharing of resources and expert coming in.
Yes, what I realize is that since I've worked in the tribunal, I've seen the ITAT also, the disconnect I see is in The system provider in the High Court is a internal system mechanism which has been created. They are not dependent on NIC. Whereas these tribunals, which operate in the form of silos, they operate largely dependent on NIC-driven system which is there. That is the one fundamental factor, because the NIC doesn't provide a comprehensive solution to a one institution-related problems. It provides a broad-based solution which are acceptable or broadly given for multiple institutions which are there. Like the Supreme Court in 2020, we faced this problem. All the revenue appeals were delayed. There was a delay in filing. And Justice Chandrachud said that, you know, there is so much of delay. What are the reasons? So we saw the reasons in the applications which are filed for condonation of delay, that the commissioner has not received the tribunal order. So he couldn't forward it to the concerned person who could have taken a decision, or the committee of the commissioners who could have taken a decision. We sat up with the system organizer from Supreme Court, including NIC, and a LIMP system is created on a central registry in the Supreme Court, is now coordinating that every tribunal is put on a system where the orders passed are uploaded on that system, which can be seen by all the commissioners located across India, which means the commissionerates are to be seen. Then the High Court similarly have been asked for. Most of the High Courts have logged onto the LIMP system, so the order is passed and uploaded, that order is visible. And today, if some commissioner sitting who is responsible to take a decision to file an appeal, that can be looked into. This has reached a point, and I have seen from 2020 till today, there is considerable improvement in terms of the delay filings which are there. Still, there are some cases which are there, but there is a remarkable filing. What I see in tribunal is, like, let's say they have 7 or 8 benches. Completely relying on the NIC system which has been given is not going to work. They need to have their internal system, and I personally understand with the allocation of a recent budget by the government for digitization of tribunals, until unless that is there.
This system is developed by NIC for us, for system. It's not a standard software which
he means, because we were just discussing this. You see, NIC has done a tremendous job. They've done a tremendous job in setting. If NIC was not there as the backbone, we would not have gone digital. But the only issue is, you see, NIC can do it broadly, generally for everybody. Correct. For example, they will not be able to do it tribunal or court specific. For that, you have to have your in-house team, because they develop the core software. Then the periphery, each court system will have slight nuances which are peculiar only to them. For that, you will need your in-house team. You can't simply depend on NIC, look, you do it. There may be small, minor issues which need some tweaking. NIC person, if you ask him, because you see, that person can't go all over the tribunals, all over the court. They will give you the core system, then peripheral system, each court will have to have your in-house team. So there has to be an in-house team, maybe start with 2, 3, 4 people. Delhi probably has a larger base because we've been digitized, everything is digital. But you'll have to have, you can't say, all right, we'll solely depend on NIC. For example, in a smaller example, in a house, if there is a fuse blown, you can't wait for the electrician or the electricity guy to come in and do it for you. You'll have a local electrician, he'll come and fix it. Where maybe a minor tweaking required, but your entire system may stop. Yes. Because you don't have an in-house person. So each tribunal will have to have an IT team. Maybe they'll coordinate with NIC at the back end, and then NIC has to take care, because we can't say minus NIC. If it's minus NIC, nothing will work. This integration that is required has to be there, and we all, like Delhi High Court has also come on board, because we need a parallel system. For example, we have to achieve a stage where all that a lawyer has to file is the appeal memo. Everything else, record, etc., should be picked up automatically from the tribunal, from the court. So you don't have to file, just file your 10-page appeal memo. Everything is there from the system, available to the court to inspect it at all points of time. For that, we need NIC as a backbone.
In fact, to add on what my lord has said, why not we think of engaging with the private sector in a transparent manner? There are very nice software companies in Bangalore and other places, etc. We could engage with services on a transparent basis. We can do an auction, basically, we can e-tender. They can quote. The government has definitely taken up for lots of projects of this nature. And build on what NIC has done. Customize it for CSTAT, for the Delhi and other benches put together. And also we can contract to them for digitizing the existing files. It's a very, very important thing, sir. Once you do that.
DRT and DRAT has recently done is, they have engaged with the private agencies to digitize the entire system. In fact, yesterday there was a petition in Supreme Court. Now they have made e-filing mandatory. So there was a petition saying that the lawyers sitting in Jabalpur, they are not in position to e-file all this. So when we looked into record that this was done in a staggered manner. So initially, 2 years back, they started saying that it's optional. Then they say up to 100 crores, this is mandatory. Then they said it's all are mandatory. And then the kiosks are set up in the all respective locations which are available for 2 hours in a day. And they can take care of, because a lot of lawyers are not equipped to file this digitally. So they were initially helping it. So when we realized that the private agency is creating, and I would assume that even the CSTAT has got the funds and the option available of engaging with these kind of authorities through a tender process. Because unless this is being integrated, all the tribunals are integrated, I don't think the delivery system will be able to be enabled to such a point where you can ask that like the High Court. High Court has the advantage because most of the judges have been in Delhi. They have seen this in last 20 years, that how the system has progressed. But that's where I see the difference, that first the institution on the administration part and the operation part, once it facilitates working, I think it's going to be, delivery system is going to be easier.
Sorry, I keep butting in because I want to share our experiences, how we've achieved this system. Before we started online, we started remote filing. Now, the issue which you are facing with the tribunals, what we did was, though Delhi is a very small place, we have district courts. District court also has a scanning agency. We provided a similar system in district courts, and we first tested that remote filing from the district courts. Before going digital, we had a counter in Tisazari, counter in Saket court, that lawyer could go there and file it from there. So High Court appeals were being filed from the district courts themselves. So when the lawyers got used to it, we found that filing was being used. We said, now go digital. So you can't straight away impose a digital system without giving them. You see, no lawyer's office, the exceptionals will be there, will like to invest in infrastructure or a technology which doesn't help him or help his office and is helping only the court. If we want lawyers to go digital, we have to provide them with the infrastructure, not vice versa.
In fact, parallelly, while this is going on, you have to probably constitute a small committee, inviting the lawyers who are appearing before you, and also the department representatives. Create that fields also, sir. Parallelly, if you can create the field by which the scanning can be done, and then it can populate that particular fields, it becomes a lot more easier for you to dispose of the matters, combine them together and do it very faster and faster. Sir, Mr. Ramanan is, as I said, the Bhishma of the department, and he has also actually worked in the systems in the department, and he has done a lot more experience in this. Sir, we would like to have your thoughts on this particular thing. How do we speed up this particular process of this?
Can I sit and speak?
Yeah, please, please. You can sit and talk, sir, like I'm doing.
In fact, when Honorable Justice took a brief walk into history, I was reminded of our two experiences. One is, we have now talked about 40 glorious years. What was the 1 year period prior to that 40 glorious years where I was part of the actor, I would say? But I'll be very brief. And the Indirect Taxation Inquiry Committee, headed by Mr. L.K. Jha, recommended the setting up of the tribunal. Because at that time, and as it always been talked about, when you had a system where the member appeals of the board or the JSRA himself was hearing, it was from Caesar to Caesar. So when the appeals were going from Caesar to Caesar, naturally, there is a bias element which cannot be totally ignored. That's how the concept of a tribunal was, in fact, promoted in the indirect taxes. There were predecessors, like, for instance, the ITAT was there, and the CIT had also come by that time. But ITAT was a typical example in as much as in the tax matters themselves, they were, in fact, the predecessors in that. And the two law secretaries who were there at that time, very illustrious people. One was R.V.S. Perishastri, who later became the Chief Election Commissioner, a very eminent jurist. and Venkat Subramaniam. And this is the kind of a team which we put in, and then when the draft was made to them and finalized when it was. One of the points which, in fact, I was strongly advocating at that time, and which answers the question that you raised just now, that, when similar or almost identical cases arise in more than one location, how exactly you bring them into one forum. In fact, when I drafted the provision for direct appeal to Supreme Court, the basic idea was have a set of special benches, be it in Delhi or any other place, where they will specialize in classification and valuation matters. And that was the idea. And when we went for sanctions, because at the time when we graduated from the existing appeal system, none of you would believe it, there were only 3,500 cases which were pending in appeals way back in 1979-80. So when I went to the financial advisor, he said, oh, if you have 4 benches or 3 benches, they will finish it off in 1 year. Why do you want 4 benches? Ultimately, one had to convince him, and he gave us 4. Now we have, fortunately, 16 benches. But a few things I had observed while handling some of these matters is the same issue. The import has taken place in Bombay, import has taken place in other places. Unless a common adjudicating authority is there, you don't really come to know how these issues have arisen there. And some are pending at some point. I would say that the special bench concept would have really taken care of this particular aspect. But somehow over a period of time, probably it had undergone a major change. Because of paucity of time, I think everybody must be wanting to, in fact, go for lunch. Now, that is the point which I wanted to make was that technology is all right, but technology or digitalization is not our goal as such. Our goal is something different. How is the judicial process going to be activated to the extent that we use to the maximum extent the technology? And the question in that is it could be both public benefit as well as private benefit. And we have to ask ourselves a few questions saying that what is the technology for? Who is the technology is for? And what is the method by which we are going to achieve it? That's where I do feel the tribunal, whatever it is, because I won't decry NIC, whatever is the impression there. The entire customs EDI system was, in fact, assisted in terms of software by NIC only. Now, in terms of capability as such, you should not, in fact, doubt NIC because they have the capability. But what really matters is the domain expert who, in fact, collaborates with them. In a dynamic law, as tax changes in customs and excise, we used to have changes taking place every day. Now, having a system which responds to those quick changes was a real big challenge. And to a considerable extent, NIC did meet up that. It's basically what kind of domain expertise which you are passing on to them. At the back of the entire mind, and we should know what we want. We'll have to prepare a business capability model for tribunal, which includes the communication channel delivery, which includes your basic data, because computer is not going to give you a thing outside what you have not put in there. The other possibility is that from another system you borrow the information of the data and then use it, which is what this Delhi Academy, I'm deeply impressed with the way it thinks. The outcomes which the Delhi High Court had achieved in this last 10 years is something amazing. Of course, that could be a kind of a blueprint for that. Now, last few words in this. Basically, apart from computerizing or automating the entire processes, we need to look at what changes we can make in the processes. That is what we generally call in industry as business process re-engineering, which we did a lot of it when we evolved the customs system, where we did away with the entire drawback department for issuing checks and all that, and we used to make a direct credit. This was as early as 1995. We did a direct credit into the exporter's account when the drawback was there. So these kinds of process re-engineering must be clearly thought of. As I was going through this, a few thoughts occurred to me. Like, for instance, we have miscellaneous matters coming up. Now, miscellaneous matters like early hearing applications and the condonation of delay and all that. We find many a time the division bench itself is hearing it. The question we'll have to ask is, should the division bench spend its time? Because after all, there are two members. If there are two members, the two members could sit separately and then deal with some of these miscellaneous matters. And things like defect correction. We have to find a way so that the time of the division bench is not taken in these matters. Even if it is 1 hour per day, it's quite a crucial time for them. And this is how you have to do that. And I do feel that the data base creation, number one, and data warehouse management, which you have to think of, is considerable, as in the Delhi High Court, as Honorable Justice mentioned, in the tribunals also. And connectivity with the customs and the service tax, which is, they are all vanishing slowly, but if any other taxes which come into the purview for getting the basic records, because even the e-court concept thinks of linking the entire system from the high courts down to the lower courts and getting some of these pieces of evidence direct from the lower courts onto the high court, even when such bail and such other things happen. So similar concept could also be thought of in this particular context, and some of the systems which already exist in the customs system or that could be linked effectively, and with due password and such other security arrangements, you will be able to look into the original document. This will be particularly relevant when customs clearances take place and live bills of entry and live shipping bills of entry, shipping bills come for adjudication before the tribunal. Today you will find even a live thing might get handled by after 6 months assignment, which in fact totally defeats the very purpose. These are the possibilities. I personally feel the tribunal has to look at it and then put down by consulting another what all they want in the system, and then link it up suitably so that from the data that, and provide also what data has to be entered into the system. And my own personal experience in planning the entire customs EDI system was that anything that is on a batch mode works very slowly and it does not work. You have got to have it online. And just as in the Delhi High Court, they had the scanning centers. In 1995 itself, we started a service center, which in fact captured all the clearance documents. Now, that is the kind of an approach we may have to adopt even for past cases. I mean, that's inevitable. The other feature which I found, the last one I will mention, I think people would be getting restive, is that in my experience, I found that in many cases, the paper book that is furnished by the advocates are all so voluminous. And ultimately, when the cases come up for hearing, what I find is maybe just about 10 pieces of papers are referred to. I think the advocates and the advocate firms also should give a serious thought to it. Because supposing there are 100 documents which are absolutely similar and identical, in the paper book you will find all the 100 would be filed. There is no necessity. Even if, because ultimately it's going to load the system. And if you are not going to look at every document, you can't expect a judge, if there are 100 documents to go through all the 100 documents. He picks up a few or two. And don't provide so much of material that also even the tribunal or the courts will get, deterred, to that.
My command. And yes, we are one of the culprits for filing the paper books, etc. I admit as well. The only problem is we also don't want to file voluminous papers. Unfortunately, the department forecast relies on hundreds of documents. And if I don't, sometimes the bench feels that we are hiding. The problem is, therefore, we need to necessarily provide those things. That is the reason. Anyway, that we are not here to discuss that. Sir, one last question to both the judges and all the members. Every time when a matter comes before me as a lawyer, I'm giving a trade secret now. I mean, we are also a lawyer earlier, sir. You know it, sir. A client comes to me and then say, here is a show cause notice, or here is an order. And now, kindly suggest what we should do, etc. I spend time, and then I say, hey, you have a good case to argue, continue. Otherwise, we say, this is bad, the revenue is right, pay the taxes. This is a practice I've been following. In fact, number of matters we advise the client to pay the taxes is much more than the number of cases we take up to argue the cases. Because the department is also right. So today, your AI has now evolved so much now. In the US, as you just now mentioned about the robotic lawyer arguing the case, there are now serious predictions possible, especially of the civil matters, especially in the IPR matters. What is the likely outcome, given the facts here, the evidence is available, and also the judgments are available? There are now reasonable predictions are available under the AI with regard to the likely outcome. I do not know whether it is in the right direction or the wrong direction, because it definitely can influence the judges, because if there is already AI has done the job, etc. But day in and day out, as lawyers, we do that. I'm sure you are also. Now the question to you, sir, is, internally, forget about us, internally, would you, and not now, in the future, 10 years down the line, 20 years down the line, you are so young, so you still have so much of time to do. Would it be possible for the judiciary to take some heavy matters and, given the best argument from both sides, what could be the final outcome? If that is known to the judges, it becomes easier for them, or maybe influencing them. Or if that is available to the public, probably they will not even fight the matter. They may go settle the matter elsewhere, etc. This is also the reason why the method by which we can reduce the litigation. Of course, I'm not talking now. I'm talking about 10 years down the line, etc. But I'm also very young, sir, so I have a lot of things to think. This is what I don't know whether they want to comment or not, etc. But this is one of the things which always occurred in my mind. See, a question from me and Balbir both put together.
This is really a very, very important topic. I'm actually working on it.
Oh.
And let me tell you, I've done a little bit of research on this AI use of technology. What I found was, and this is something which the US courts were facing a difficulty. You see, AI can do a tremendous job in terms of permutation, combination, calculation, much faster than what we can. Probably it'll do it in seconds, what we'll do it in years. But the problem with that is this. The historical data, and this was experienced in US at one point of time when they tried using AI. If the historical data, because in computer terminology, I'm actually a computer graduate also. So computer terminology, there is something called GIGO.
Yes.
Garbage in, garbage out.
Correct.
So what garbage is fed in will give out garbage. Now, in context, historically they found that their judgments were pro-white and anti-blacks. Now that was the historical data. And that historical data showed that when it came to a colored person, the judgment will be harsher. When it came to a white, judgment would be more lenient. So the system that they developed, system that they found, that if they were to assess at the time of sentencing, why it would be lenient was because historically they felt that the colored people would be more prone to repeating crimes and committing crimes than the whites, whereas that was actually not correct. So that historical data led to AI giving up incorrect results. That's a major fallout. So if we feel that, yes, we can use technology, the one slide that I showed was that, look, your judgments the percentage of your judgments are incorrect are also percentage of the judgments of AI being incorrect. But if we were to develop a system, one thought is that it might be anti-constitution. For the reason we have a system of appeals. The fact that we have appeals provided presupposes that a judge may be incorrect, may miss out something. But if you have an AI system installed, for example, say in the first court, the tribunal, and that AI system is used and it gives out a result, and we feel, yes, this is a plausible result, then where is the question of an appeal? Because the High Court will have the same system, the Supreme Court will have the same system, the result will be the same. And the dynamism that we have seen, the volumes of judgments, the volumes of dynamism that a judge has come up with a novel idea and looked at it from a different perspective, AI would never be able to do that.
The application of mind, per.
Yes.
The very basic
And
justice delivery system required.
in criminal trials, civil suits, when a person is in a witness box, we say, watch the demeanor. AI will not be able to watch a demeanor that he's hesitating in answering, or he suddenly started sweating when an uncomfortable question is put. AI, yes, to certain extents can be used. That is why if AI was there, we had something like Watson. Watson was a computer which developed, which gave a answer, but they've not accepted it. It's not been accepted world over because there are a lot of cautions. So we are still probably far away.
And decided, I mean, in fact, advisedly, so my purpose of asking this question is that AI can be used as a tool, as a handmaid, but it must use has to be limited to a particular level. And beyond that, human brain has to be given that particular power of deciding what is right, what is wrong. And that's where you're doing this.
Yes, you see, as lawyers, what Mr. Lakshmi Kumaran said, and we also used to follow that. We would advise a client, look, you have a weak case.
Yes.
You may not succeed.
Yes.
But he may still insist on going ahead. And on the lighter side, I'll give you an example of what happened actually in our office. My father was a rent control lawyer. He was practicing on the rent control side and one of the best in the country on that. Anyways, so one tenant came to him with his case. So he said, look, you don't have a winning case, so settle with the other side and do it. He said, no, give me back my file. He took the file and went away. So 10 years down the line, again in court, that person met my father. He said, remember me, you had advised me 10 years ago that I'll lose. I lost, but it took 10 years for the landlord to get possession. So, you see, sometimes there are these fallouts for it. We may advise the client, look, it may not be worth it, but he may still say, no, I want to go and litigate, I want to challenge it, because tomorrow the department may settle at a lesser amount. These are fallouts because of a delay in system. That is why technology is being used. We ideally want to reach a system where a litigation is filed and 6 months there is a closure up to the Supreme Court. We are trying to, we have moved substantially. By use of technology, we move substantially. But we are still a little way away from actually achieving that. And in the near future, we're sure we would be able to.
Thank you very much. I think I have taken more time than I think people are, they're very polite in not reminding me. So I thank you very much, all the panelists here, and especially, sir, you're giving the map from the original, from what it was. In fact, this generation has seen all. That generation has not seen, but we have seen this completely. From the slate, from writing the paper, the ink bottle and the pen, which I used to carry at my school. Then fountain pen was a great invention. Ballpoint pen was the highest. That was the highest.
The true friend was who would share that drop of ink from his fountain pen into your pen. He used to be a true friend.
Thank you very much, all of you. Thank you very much for the question.
I think we had an excellent session regarding this digitization and technology, etc. I think all the speakers here deserve a standing ovation for the way they have explained the whole thing, and then it has been an excellent, enriching experience for all of us. Thank you very much, all of you. And we will now break for lunch, and we will have the second session. Of course, we are running, I think, behind schedule. So we would request you to, kindly be seated. I'm sorry. We now have amongst us Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India. And he is, of course, going to lead the discussions in the second session, which will be starting post-lunch. And, of course, he'll be joined by other eminent speakers, Justice Sunita Agarwal from the Allahabad High Court, and then the other members of the CISCHAT also. We warmly welcome Honorable Justice Pankaj Mittal for this celebration and occasion.
We are now breaking for lunch. I'm requesting everyone sitting, especially the young guest at the back, to kindly remain seated till the dignitaries on the dais and the senior members of our guest are leaving the auditorium. Thank you so much. We will be coming back by around 2:45 to start our second session. Starting with the second technical session of today's program, which is about experiment of tribunals, triumph and tribulations.
We'll be having the second technical session today, which is on the subject relating to use experiments of tribunals, the triumphs and tribulations. To discuss this, we have amongst us Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India, Honorable Ms. Justice Sunita Agarwal, Judge, Allahabad High Court, Mr. C.J. Matthew, Member Technical CSTAT, Mr. C.S. Loda, Senior Advocate, and Mr. Gauri Shankar Sai Kumar, Advocate. May I now request Ms. Hemambika Priya to welcome Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India, with a plant.
धन्यवाद। अब मैं श्री सोमेश अरोरा से अनुरोध करती हूं कि कृपया न्यायमूर्ति माननीय श्री पंकज मित्तल, न्यायाधीश सर्वोच्च न्यायालय को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Ms. Binu Tamta to please welcome Honorable Ms. Justice Sunita Agarwal with a plant.
धन्यवाद। अब मैं श्रीमती रचना गुप्ता से अनुरोध करती हूं कि कृपया माननीय न्यायमूर्ति श्रीमती सुनीता अग्रवाल, न्यायाधीश इलाहाबाद उच्च न्यायालय को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Sunil Kumar Gupta to please welcome Mr. C.J. Matthew, Member Technical, with a plant.
धन्यवाद। अब मैं श्री पीपी जडेजा से अनुरोध करती हूं कि कृपया श्री सीजे मैथ्यू, सदस्य तकनीकी, को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
May I now request Mr. Prashant Srivastava to kindly welcome Mr. C.S. Loda with a plant. Where is it? नहीं है?
धन्यवाद। अब मैं श्री विशाल अग्रवाल से अनुरोध करती हूं कि कृपया श्री सीएस लोढ़ा को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
I now request Ms. Javaria Kainath to kindly welcome Mr. Sai Kumar with a plant.
धन्यवाद। अब मैं श्री अखिल शिराजी से अनुरोध करती हूं कि कृपया वो अधिवक्ता श्री गौरी शंकर साई कुमार को स्मृति चिन्ह भेंट करके उनका स्वागत करें।
Before we commence the second session, a brief introduction about our speakers. Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India, graduated in Commerce from Allahabad University in 1982, And in 1985, he completed his LLB, and in the same year, he was enrolled as an advocate in Bar Council of Uttar Pradesh. He belongs to a family of lawyers, and his father was also a judge of the Allahabad High Court from 1978 to 1992. Before being elevated as an additional judge in Allahabad High Court in 2006, Justice Mittal had an illustrious practice in the Allahabad High Court, specializing in matters pertaining to land acquisition, rent control, education, labor, service, and constitutional law. After serving as a judge at the Allahabad High Court from 2008, Justice Mittal took oath as the Chief Justice of the Common High Court for the Union Territory of Jammu and Kashmir and Union Territory of Ladakh on 4 January 2021, and later went on to become the Chief Justice of the Rajasthan High Court in October 2022. He became a judge of the Supreme Court in February 2023. Well known for his writing, Justice Mittal's article titled The Birth and Life of the High Court of Judicature at Allahabad, which traces the Allahabad High Court's history, is widely read. During his tenure as the Chief Justice of the Common High Court for the Union Territory of Jammu and Kashmir and Union Territory of Ladakh, he played a pivotal role in advancing the Ladakh Legal Services Authority. In all these years of his tenure as a judge, he has delivered landmark judgments on various important topics spanning across preventive detention, right to decent and dignified cremation and lost rights, land acquisition matters, etc.
Our next speaker and our guest today is Honorable Ms. Justice Sunita Agrawal. Justice Sunita Agrawal is serving as a judge at High Court, Allahabad since 2013. In tracing her history at the bar, Justice Agrawal earned her Bachelor's of Law from Awadh University in 1989 and was enrolled with the Bar Council of Uttar Pradesh in 1990. She had an excellent practice and advocate in Allahabad before being appointed as Additional Judge of Allahabad High Court in 2011. During her tenure as a judge, Justice Agrawal has delivered several important rulings with respect to constitutional law, private property disputes, IBC, criminal law, including life sentences, land acquisition, etc. Her progressive sentence in promotion of rights of LGBT community is reflected in one of her recent landmark judgment, which holds that dismissal of a home guard based on a video clip displaying affection towards their partner amounts to discrimination on the basis of a person's sexual orientation and therefore unlawful. Being one of 6 women judges of Allahabad High Court, Justice Agrawal has been extremely proactive in organizing workshops for gender awareness and sensitization, and is also a member of panel appointed to hear complaints concerning sexual harassment at Allahabad High Court. Madam, we welcome you in the panel discussion.
We also have, as one of the panelists, Mr. C.J. Matthew, Member Technical Assistant. Mr. Matthew, an officer of the Indian Revenue Service, worked in different capacities in different parts of the country from 1990 till he was selected as a member of the CSTAT. Mr. Matthew was Secretary Council for Clean India, an initiative of then Central Vigilance Commissioner. He was on the board of Cochin Port Trust from 2005 to 2011, contributed to decisions on many works projects of the port as member of the board and in subcommittees. He is a regular resource person at Indian Institute of Management, Bengaluru, offering a session on business innovation through government offerings. Mr. Matthew is also a regular resource person in various courses offered by Indian Institute of Foreign Trade, particularly on ACZs, logistics, and indirect taxes. And I'm told he is also a regular half-marathon runner. We kindly welcome Mr. C.J. Matthew.
Our next eminent speaker is Mr. C.S. Lodha. Mr. C.S. Lodha obtained his law degree in 1972 from University of Allahabad. After his law graduation, he joined DCM and after 4 years, moved to Hindustan Lever Limited Unilever Company as legal manager. Having acquired extensive experience in industrial law, corporate laws, competition law, indirect taxation, and other areas, Mr. Lodha left in 1983 to set up an independent law practice as counsel and advisor, specializing in direct taxation and various commercial laws. Presently, he is associated with various multinational and large corporate houses to handle their litigation and advisory work. Since 2001, he is the president of Bar Association of Lawyers of this specialization. He is endeavoring to set up chapters for continuing legal education for young aspirant lawyers, both in industry as well as in practice. He is also extensively involved in sharing experiences with legal managers and industry through training courses and seminars. Sir, we welcome you today in today's session.
Mr. Gauri Shankar Sai Kumar, advocate, has been practicing as an advocate since September 1993. He has rich experience in handling various matters inter alia relating to both direct and indirect tax, company matters, criminal matters, commercial and contractual litigation. He has represented high-profile clients in various litigations before various forums, including Supreme Court of India, Delhi High Court and other high courts, NCLT, NCLAT, etc. During his career, he has advised and acted for a number of Indian and foreign companies on transactions relating to corporate structuring and restructuring, cross-border transactions, asset purchases, etc. He is a specialist in corporate commercial strategy, arbitration and dispute resolution, trust matters, and the application of economic and commercial laws in various business fields. He has also authored treatises on commercial laws and taxation and has been an eminent speaker in several national and international forums. He is also noted for his sectoral expertise in clinical research services and the medical legal sector. We welcome Mr. Gauri Shankar Sai Kumar, please. With this introduction, may I now request the panel speakers to start the technical session on the subject of tribunals, crimes, and tribulations. Thank you.
Shri Gauri Shankar Sai Kumar would be the moderator of today's session, please.
Thank you very much and welcome you all for this particular session. The experiments with tribunal, triumphs and tribulations, deals with the concept of tribunals when it was first introduced in India, probably in 1941, when Income Tax Appellate Tribunal came into existence by way of an amendment to 1922 Act in 1939. From that point onwards, till about 1976, when the 42nd Amendment to the Constitution came in, when Article 323A and 323B were inserted, along with some infamous articles, which were later corrected by the 44th Amendment. That gave the tribunals the strength from the Constitution, which I think the panel today should take forward and see where we have started and where we have reached and what is the way forward. So I leave it to Justice Pankaj Mithal, Honorable Justice Pankaj Mithal, the Judge Supreme Court of India, to start. I think I was put into a fix here by saying I will be the moderator. So he can take forward and moderate, and I'll be there to assist him. Thank you. Better, that'd be better. So let's start with you, sir. I invite Justice, Honorable Justice Mr. Pankaj Mithal to speak first.
Every speaker wants to speak separately.
Yeah, that'd be nice.
C-State, my sister from Allahabad, Justice Sunita Agarwal ji, Shri Matthew, Member Technical, Shri Loda, Senior Advocate, and Shri Sai Kumar, Advocate, other dignitaries present in the hall, Mr. Lakshmi Kumaran, who is sitting just in front of me, other distinguished guests, ladies and gentlemen. It gives me a great pleasure to be a part of this special occasion to commemorate the 40 years of the Customs, Excise and Service Tax Appellate Tribunal. Such occasions, in addition to providing a platform to acknowledge and appreciate the good work
that has gone into in making of the institution also extends an important space for indulging in introspection of the road traversed. This tribunal has played an exemplary role in institution building in the domain of indirect taxes. I think the biggest triumph of CSTET has been that they have been so adaptive in their approach towards changing tax policy from gold control to custom facilitation, from opening up of manufacturing to the introduction of service tax, from evolving jurisprudence of classification and evaluation to appreciating the nuances of the cross-border transactions, including overvaluation, and finally dealing with extremely technical and technologically related issues, the taxing of which is the subject matter of contention globally. CSTET is one of the few tribunals in India in which professionals such as chartered accountants, cost accountants, company secretaries, and even certain retired officials of the Central Board of Direct Taxes and Customs are keenly associated. Thus, it is always brimming with energy and encounters almost on daily basis the platform to explore the nuances of tax legislations and jurisprudence with expertise. Given this unique vantage point, it should also be the right nursery for nurturing and promoting young talents. The success of CSTET shall open the doors to a robust and concrete GST tribunal, which is due to come very shortly. We are in a very crucial stage in the implementation of the GST tribunal. As we move ahead in the GST era, the best practices of the CSTET would easily be replicated in the GST tribunals, and that could mutually strengthen both the institutions. Now I begin by giving a brief history of the tribunals in the country, which though may be very elementary, but nonetheless, I explain the background. The Indian legal system, as is perceived by the common man, it consists of three-tier system for the adjudication of trials and disputes and complaints of the general public, and that intersee the private individuals and the state authorities. At the lowest level, we have the district courts consisting of the civil judge, junior divisions, and the judicial magistrate for civil and criminal cases, respectively, headed by the district and session judge exercising civil and criminal jurisdiction, both. This is implicit from the Bengal, Agra, and Assam Civil Courts Act 1887. Then we have the high courts, and finally Supreme Court at the top. Now, of course, Gram Nyayalayas have been added at the bottom in the hierarchy of the judicial system. Tax administration is undoubtedly a complex issue which, with amendments after amendments, provisions with exceptions, provisos, cross-references, complexity of the tax laws, and the maze created by it can be well understood by none other than great Naini Palkiwala, who once said, "The time has come for Parliament to enact some new legislation, say Prevention of Cruelty to Taxpayers Act, which should override all fiscal legislations." It is quite surprising to note the complexity of the tax laws in a country where the man of the millennium, Mahatma Gandhi, who was known for simplicity, lived and walked. Speedy justice is perceived as a tax incentive, and therefore it was considered to be one of the most important aspects of the administration of tax regime. Thus, revolutionizing the Indian judicial system, the first tribunal, that is the Income Tax Appellate Tribunal, was constituted on 25th January 1941, as my learned friend pointed out. Initially, 3 benches, one each at Delhi, Calcutta, and Mumbai, were established.
which have progressively increased to 63 branches at 27 different locations. The experiment with the income tax appellate tribunal proved to be very successful, as it is functionally proved to be very successful, and it is functional well and is rendering human services. It hastened the need for specialized tribunals. The report submitted by the 14th Law Commission of India recommended for the development of a system that would reduce the backlog of the high courts, and thus suggested creation of tribunals. In tune with the tribunalization adopted by many countries, India also recognized the need for establishing tribunals to provide for adjudication of disputes in specific fields by persons with expertise so as to provide speedy justice in certain kinds of cases. Accordingly, a radical change was brought about by the Constitutional 1976 Amendment with effect from 3rd of January 1977 by inserting new Part 14 capital A in the Constitution of India regarding the constitution of tribunals. The said part added Article 320A and 322B of the Constitution, empowering the Parliament to provide for the establishment of the Central Administrative Tribunal for the services, matters relating to services, and for various other matters under Article 323B, which included enforcement of tax, foreign exchange, import and export, industrial and labor disputes, etc. The statement and objects and for the aforesaid amendment reads as under: to reduce the mounting arrears in high courts and to serve the speedy disposal of service matters, it is considered expedient to provide administrative tribunals for dealing with such matters, while preserving the jurisdiction of the Supreme Court in regard to such matters under Article 136 of the Constitution. Similar was the object of the enactments framed under Article 323B. The main purpose was to ease out the explosion of workload in the high courts or the Supreme Court, and for rendering speedy justice by providing an expert body for dealing with such matters. It is in pursuance of the provisions of the Article 323A and 323B that Parliament enacted the Administrative Tribunal Act 1985 to establish an administrative tribunal for the Union of India, a separate administrative tribunal for the state, or a joint administrative tribunal for two or more states. In dealing with the validity of the Administrative Tribunal Act 1985, now here comes the main case of Sampath Kumar, and it was held that the tribunal should be a real substitute for the high courts, not only in form and de jure, but in content and de facto. The matter was referred to the 7 judges later on, and the 7-judge bench of the Supreme Court in L. Chandra Kumar held that Clause D, 2D of Article 323A and Clause 3D of Article 323B of the Constitution, to the extent they empower the Parliament to exclude the jurisdiction of the High Court and the Supreme Court under Article 226 and 227 and 32, respectively, of the Constitution are unconstitutional. The jurisdiction confers the High Court under Article 226, 227, and that upon the Supreme Court under Article 32 of the Constitution were held to be part of inviolable basic structure of the Constitution. Thus, all decisions of the administrative tribunals were subjected to scrutiny before the division bench of the concerned High Court. Now, later this Central Administrative Tribunal was followed by the Armed Forces Tribunal by an Act of 2007, and the matters in respect of persons subject to Army Act, Navy Act, and the Air Force were brought within the ambit of the AFTs. The Armed Forces Tribunal was inaugurated in August 2009 by the President of India. Now it has a principal bench at New Delhi, and the regional branches at various places, Chandigarh, Lucknow, Calcutta, Guwahati, Chennai, Kochi, Jabalpur, Srinagar and Jaipur. Similarly, a National Green Tribunal was established for disposal of cases relating to environmental protection and conservation of forests in the year 2010, and then certain amendments were made in the Companies Act 2013, and the NCLT and NCLAT was established. And in addition to the above, we have several other tribunals, consumer dispute redressal forums at district level, state level, and the national level, Central Government Industrial Tribunal, Appellate Tribunal under the Smugglers and Foreign Exchange Manipulators Act, Railway Claims Tribunal, Securities Tribunal, DRT, Telecom Dispute Settlement Tribunal, and Electricity Appellate Tribunal. In all, we find that about 18 tribunals under the Central Acts are functioning at present. Now, besides all these tribunals, the Custom, Excise and Gold Control Tribunal, CGAT, was established under the Customs Act in 1962 as a quasi-judicial body to hear appeals under the Customs Act. On the introduction of the service tax by Chapter 5 of the Finance Act of 1994, the jurisdiction of the service tax was also added to the CGAT. Accordingly, its name was changed to Custom, Excise and Service Tax Appellate Tribunal, CSTAT, with effect from 14th May 2003. CSTAT was created to provide independent forum to hear appeals against the orders passed by the Commissioner of Customs and Excise and Service Tax under the Customs Act, Central Excise Act, and the Finance Act 1994, respectively. The tribunal is also empowered to hear appeals against the orders passed by the designated authority in anti-dumping duties under the Customs Tariff Act 1975. It also hears appeals concerning customs house agent licensing. The creation and establishment of the above tribunals progressively demonstrate that the country is now in the era of tribunalization. Now, these tribunals were established, and the experience, apart from that of the Income Tax Appellate Tribunal, that was not very good. The working came under hot criticism, and various kinds of ills were pointed out, and these ills were taken care of by the Supreme Court in one of the leading cases, Roger Matthew versus South Indian Bank. Now, in this case, it was observed that since executive is the litigating party in most of the litigation before the tribunals, it cannot be allowed to have a dominant role in judicial appointments of the chairpersons, members of the tribunal, on the basis of the principle of exclusion of executive control over judiciary, which is not limited to traditional courts alone, but extends to tribunals also, because they are alternative to the courts and supplement judicial functions. It was also opined that members and presiding officers of the tribunals cannot be removed without the concurrence of the judiciary or in the manner specified in the Constitution for the removal of judges of the constitutional courts. A further observation was made that central government cannot be allowed to have administrative control over the judiciary without subverting the doctrine of separation of powers. As a sequel to Roger Matthew, when the amendment of the Companies Act 1956, which provided for the establishment of NCLT and NCLAT, came up for consideration before the Supreme Court in Madras Association case, Madras Association case, it was opined that while it cannot be said that the legislature is denuded of the power to transfer judicial functions performed by the courts, nevertheless, independent judicial tribunals for determination of the rights of citizens and for adjudication of the disputes and complaints of the citizen is necessary commitment of the rule of law, and that judicial independence and separation of judicial power from executive are part of common law traditions implicit in the Constitution. This three-judge bench, noting that tribunalization drew large criticism through this, though the system had its own advantages, in order to maintain independence of the tribunals and to ensure their freedom from executive, directed to constitute a national tribunal commission, not yet constituted, to act as an independent body, to supervise the appointments and functioning of the tribunals, to conduct disciplinary proceedings, and to take care of administrative and infrastructure needs of the tribunals in an appropriate manner. It further provided that till NTC is constituted, that is the Commission for the Tribunals, a separate wing of the Ministry of Finance, Government of India, shall supervise and deal with the requirements of the tribunals. In order to overcome the executive interference, in the search and selection committee of the chairperson and members of the tribunal, it was held that judicial dominance in the composition of the search cum selection committee is necessary to ensure independence of tribunal. Thus, it was provided that instead of 4-member search cum selection committee with Chief Justice of India or his nominee, outgoing sitting chairperson or president of the tribunal, and 2 secretaries of the Government of India, the search and selection committee shall comprise of 5 persons. Now, those 5 persons have been laid down in the judgment itself, and since the commission has not yet been formulated and made functional, these directions are binding and are to be followed by the government. But despite these guidelines and the directions, we find that the appointments of the members and the chairpersons are taking a lot of time. Most of the vacancies are lying vacant, and virtually in most of the states, and the benches are without functioning without members. This Madras Bar Association judgment further holds that tribunalization is necessary for speedy disposal of disputes in a specific field and to lessen the docket of explosion of the cases on the judicial system of the country. But these tribunals cannot act as substitutes of High Court and Supreme Court, and their functions are only supplemental to the courts. While it cannot be disputed that vacancies in tribunals should be avoided and that members of the tribunal must be appointed quickly in accordance with the extant law and guidelines laid down by the Supreme Court, it is important to underscore that technology can play a crucial role in dispensing quicker solutions to tax litigation. As observed by the Chief Justice of India, technology for dispensation of justice is here to stay and is not a stopgap arrangement owing to the COVID-19 pandemic. Thus, the investment made in technology, even in the case of tribunals, should not go waste and be put to optimum utilization, particularly to fill up the gaps when the benches do not sit in certain cities, owing to issues of vacancies therein. Technological tools like video conferencing solutions, transcription, dictation tools can be incorporated into day-to-day process to speed up disposal of cases. Artificial intelligence-based assistance could be another potential technology-based solution that could help reinvent the operational process in terms of scheduled hearings, clerical assistance, indexing, etc. Being open to such technological possibilities and cautiously adopting them is a necessity in the era of this tribunalization in which we are living. Now, with the creation of these tribunals, we can go on highlighting the triumphs and the drawbacks, but all these have been taken much care of by the Supreme Court in the 2 judgments, the Roger Matthew and the sequel to the same. And I think the panel may, if like to elaborate, may elaborate on it, but I need not go into it in details. In the end, I would only make one or two suggestions of mine with regard to the working of the tribunals. This is an era of tribunal, and at this stage we cannot say that it is not good for the system or that we should totally avoid these tribunals. The tribunals having been created and are functional, the certain reforms alone are needed to them to streamline their working. Now, one of the main problem which is faced by the tribunals is that these tribunals are scattered throughout the city. One tribunal is situated in the south of Delhi, the other in some other place, and similar is the situation with the tribunals in other cities like Srinagar, Chandigarh, etc. Now, the lawyers face a lot of difficulty in moving from one place to another, and they resist establishment of tribunal outside the campus of the High Court. This I experienced in Jammu and Kashmir, where the CAT was established at a different place. The lawyers went on a strike and they insisted that it should be within the High Court campus itself. But that was not possible for the government. Now, for this, my suggestion is that the government should come out with a clear picture as to how the infrastructure has to be provided for these tribunals. They should be lodged in one building, maybe in one campus, so that these difficulty in moving from one tribunal to other, that could be avoided. I experimented with this also while in Allahabad. And in one of the PILs, an order was passed by me that the state officer should explore the possibility of having a one centralized building. Now, the union government came out with a Kendriya Bhavan, 7-story Kendriya Bhavan, and each floor there was a separate tribunal established. And it eased out the various difficulties of the lawyers and the litigants. This is one aspect. The second suggestion which I want to give is that under each of the act where tribunals have been created, a different procedure has been provided for filing of the petitions and for all other purposes. Now, say even the limitation for filing a claim or an appeal, in some cases it is provided 30 days, 15 days, 45 days, 60 days. Now, this is at variance. When we are having a tribunal system, we should have a uniform law and the uniform procedure for the purposes of filing and dealing with the complaints and the appeals. And the limitation should also be a uniform one. In some cases, there is a power to condone delay, but subject to only a maximum of 30 days, 90 days, or so on. So it has to be a uniform procedure. This will help out in easing the difficulties in the functioning of these tribunals. In the end, I would conclude by saying that tribunals have been an important addition to the Indian judicial system, and they have brought several benefits, including reducing the backlog of cases and improving the efficiency of the justice system. However, they have also faced several challenges, including issues related to their independence, efficiency, quality of decision making. To ensure the effectiveness of the tribunal in India, it is important to address these challenges and to ensure that they function in a transparent, independent, and efficient manner. Thank you. That's all.
Thank you very much, Justice Pankaj Mehta, for a very nice speech and a deep insight which you gave regarding the workings of the tribunal and the constitutional provisions as well as the interventions of the Supreme Court and the suggestions regarding the improvement of the tribunals, including the procedural aspects which you just said. Thank you so much, sir. May I now invite Honorable Justice Sunita Agarwal.
Very good afternoon to all of you. Honorable Mr. Justice Pankaj Mittal, Judge Supreme Court of India, the panelists on the dais, Justice Dilip Gupta, President SESTAT, members SESTAT, my colleagues from Delhi High Court, members of other tribunals, distinguished lawyers over here, guests, ladies and gentlemen. Considering the docket the courts in India are handling on day-to-day basis, having first-hand experience as a judge of the High Court at Allahabad, tribunals are indispensable part of the justice dispensation system. The judicial bodies in the name of tribunals came into being with the insertion of Article 323A and Article 323B in the Constitution by 42nd Amendment in accordance with the recommendation of the Swaran Singh Committee. Technical aspects of the taxation laws made it imperative to have specialized bodies to deal with the disputes at various levels. The appellate jurisdiction of tribunals such as CSTAT has been a great respite to both the taxpayers and the constitutional courts, especially the high courts. Importance of trade and commerce in shaping the country's infrastructure cannot be underestimated. Ease of doing business is the basic tenet of the growth of economy of the country. Interplay of the right of the taxpayers, anxiety of the revenue is balanced by the tribunal with the amalgamation of judicial and technical members. For resolution of disputes, penalization of defaulters, independence and transparency in the working of tribunal is very much needed. Government being the main litigant in tax matters, as highlighted by Justice Dinesh Maheshwari, in his inaugural address, paradigm shift is needed in the mindset of the revenue officials from being a compulsory litigant to a responsible litigant. While presiding over a tax bench, my experience is also the same. In a matter where the Supreme Court has decided the legal principle and the second appeal, and the appeal before the High Court is in the nature of second appeal, the revenue filed the appeal just to get it dismissed from the bench of the High Court. When I called the explanation of the concerned officer, the explanation was that the officer who was in charge of litigation, he was adamant to file appeal before the High Court. The Tribunals Reforms, Rationalization and Conditions of Service Ordinance 2021 came to be challenged in the Supreme Court. It was met with criticism for not only bypassing the usual legislative process, but also for abolishing several tribunals. Despite the Supreme Court's directions in Roger Matthews' 2019 judgment, no judicial impact assessment was conducted prior to abolishing the tribunals through the ordinance. While the ordinance has incorporated the suggestions in Madras Bar Association 2020 judgment on the composition of search cum selection committee and its role in disciplinary proceedings, It has fixed a 4-year tenure for chairpersons and members of tribunals. Notwithstanding anything contained in any judgment, order, or decree of the court, by blatantly disregarding the court's discretion for fixing a 5-year term. The Center is yet to constitute a National Tribunal Commission, an independent umbrella body to supervise the functioning of tribunals, appointment of and disciplinary proceedings against members, and to take care of administrative and infrastructural needs of the tribunals. The idea of NTC was first mooted in L. Chandrakumar, 1997, by the Supreme Court, but it has not seen the light of the day. Initiating dialogue and promoting awareness about the National Tribunal Commission is vital for overcoming the government's inertia in establishing such a body. Developing an independent oversight body for accountable governance requires a legal framework that protects its independence and impartiality. The NTC must be established by the constitutional amendment or be backed by a statute that guarantees it functional, operational, and financial independence. The NTC could therefore pave the way for the separation of the administrative and judicial functions carried out by the tribunals. In L. Chandrakumar, 1990 judgment, in a separate but concurring judgment, Justice Ahmadi has emphasized, I quote, "A sound justice delivery system is a sine qua non for the efficient governance of a country wedded to the rule of law. An independent and impartial justice delivery system in which the litigating public has faith and confidence alone can deliver the goods," I unquote. It is a time that a body like the Law Commission of India has a comprehensive look in with a view to suggesting measures for their improved functioning. What constitutes threat to independence of tribunals? Lack of standard qualifications for appointments of members of tribunals. The conditions prescribed are not comparable to that of any independent institution. Jurisdiction of a tribunal can be abolished by simply repealing its parent statute. Tribunals are dependent upon the appropriate government for the grant of funds for meeting their daily expenses. The Supreme Court, being the superior court of India, is to oversee the judicial decisions rendered by those who man the subordinate courts and tribunals, and that they do not fall foul to strict standards of legal correctness and judicial independence. So the way forward, to my opinion, is that until a wholly independent agency for the administration of all such tribunals can be set up, it is desirable, as observed by the Supreme Court, that a single nodal ministry which will be in a position to oversee the working of tribunals shall be assigned. It would be open for the ministry in its turn to appoint an independent supervisory body to oversee the working of tribunals. This will ensure that the entire system will not languish for inefficiency or lack of interest by the persons who are holding the position of president or chairperson of a tribunal. The creation of a single umbrella organization will, in my view, remove many of the ills of the present system. If the need arises, there can be separate umbrella organizations both at central and state levels. Such a superior authority must try to ensure that the independence of members of all such tribunals is maintained. The inordinate delay in filling the vacancies of members and chairpersons of tribunal has resulted in emasculation of tribunals. The main reason for tribunalization which is to provide speedy justice, is not achieved, as tribunals are wilting under the unbearable weight of the exploding docket. To make it the safeguards which ensure independence and impartiality are not only for promoting personal prestige of the functionary, but for preserving and protecting the rights of the citizens and other persons who are subject to the jurisdiction of the tribunal, and for ensuring that such tribunal will be able to command the confidence of the public. Freedom from control and potential domination of the executives are necessary preconditions for the independence and impartiality of judges. To make it clear that a judiciary free from control by the executive and legislature is essential. If there is a right to have claims decided by judges who are free from potential domination by other branches of government. I now throw the discussion to the panel on the topic. Thank you so much.
Thank you, Justice Agarwal, for your kind words regarding the important role the tribunals are playing, and also your suggestions for improvement in terms of appointment of members, the service conditions, and also the need for National Tribunal Commission, which is well taken. Thank you so much. May I now invite learned Mr. C.J. Matthew, Honorable Technical Member, to say a few words. Thank you.
Thank you, Mr. Sai Kumar, for inviting me to address the August gathering, which has a spectrum of all shades of opinion, all shades of experience. But I would cavil about your not discharging your duties as a moderator, because sometimes we take extreme views, and that is where a moderator is required. So you should take up that task. It is my privilege to be here in a company of eminent jurists such as Honorable Justice Pankaj Mittal, Honorable Justice Ms. Sunita Agarwal, legal luminaries like Mr. Sai Kumar and Mr. Lodha, and for which I should be thankful to the Honorable President of the Tribunal, Mr. Justice Dalip Gupta, for giving me this opportunity to be here. To address a subject which is, of course, very close to our hearts, especially those of us who have been on the tribunal for some time, who have had experience with the tribunal from outside too. It is now 46 years since the constitutional amendment that enabled the setting up of tribunals was enacted. It is 4 decades since this tribunal itself was established. It took 4 years between the empowerment under the constitutional amendment for the law to be drafted and enacted. It took 2 more years for that law to come into place and get implemented as the tribunal, the SIGAT of those days. Today we have a tribunal which exists in law. which has existed in law after that major paradigm shift in commodity taxation, the goods and service tax. It did not need this run-up, but nonetheless, it has not come into existence as yet. And you can imagine the consequences. 6 years of operation of a law, 6 years of operation of disputes. It is going to start off with an overburden of cases. It will not have the privilege and that infant nurture which the CSTAT went through or the CGAT went through. It will not have that age of innocence of developing its own practices and procedures because it has to hit the ground running. That there has been this reluctance or delay in setting up the tribunal could probably be a scathing indictment of the manner in which tribunals such as the CSTAT have functioned. For let's not flatter ourselves that we have a caseload which is terribly huge, and it takes quite some time to get back that state where it's manageable and meet that end for which it was created, speedy delivery of justice. At the same time, it could also be the immense success of this tribunal and other tribunals of its ilk, which is probably the cause of this delay. After all, interposing between the tax administrator and the taxpayer and guiding the movement of taxation in a particular direction, and more so in shepherding the enforcement agencies within the framework of the law, may not be too pleasing, where the Treasury needs to expand its own sources and its own resources. In order to understand why this could be so, perhaps I could find no better choice of an advice from J.K. Rowling, of course, addressed through one of her characters, that to confront the unknown, what is least familiar, and make it commonplace, it is better to give it a name and understand what it is. Most of us labor under a misconception that a tribunal is actually a substitution of an existing judicial jurisdiction, or that it is a pit stop in an existing judicial continuum. Now, all that we have to do is look at our own tribunal and see whether we can place it within that, and you will find that it's not possible. So there's something else beyond all this to tribunalization. The ingredients of tribunalization, that will probably give us a clue as to what tribunals are all about. To look at the first aspect, it is where the state has a material stake. The state itself has a material interest in the outcome of a dispute. Unlike in criminal disputes where the state acts as a proxy. What is in contention are administrative decisions, not problems between two individuals. So there is an administration on one side and there is an entity on the other side who are in contention before the fora. Third is what we can call outcomes. An outcome in such a problematic ambience, an outcome which is actually correct. An outcome, if it is not correct, or if it's not possible to be correct, at least the most preferable. This is what makes tribunalization what it is. In other words, there is a problem normally initiated by the state, and there's a solution in which a state and an entity are in contention, and there's only one winner. We could call it, or it has been called, merit review. Merit review where the appellate structure stands in the place of the decision maker and takes a view. And if that view taken by the original decision maker is not correct, to redraw the outcome, as opposed to a judicial review. In a judicial review, it is a striking down of a decision, a striking down of a provision, probably with a direction to reconsider. There is no corrective which takes place, or there's no standing in the shoes of the original decision maker, which is what sets apart tribunalization from the normal judicial pattern which exists. So effectively what we do is we are marrying two disparate streams. One is determination and the other is virus. So what happens in the process is we have the judicial institutions like the High Courts and Supreme Court which take the place of the original authority and give an outcome, a viewpoint in that particular dispute. Well, that is as good as it goes, well and good. But there is a substantive deviation from what we normally would consider a pure tribunal form. If we take the example of Australia, in Australia, there is a tribunal, and that tribunal is an option. A litigant has an option to go before the tribunal and close the litigation there with the decision of the tribunal being final. There is the alternative of going through the judicial route. Ultimately, it's not that the tribunal's ruling is final. The tribunal's ruling is subject to judicial determination through a judicial review. But by bringing the two together in our theater of experiment, we have created our own problem in the process. Doubtlessly, this decisions taken by the highest court of the land give us a wealth of material of ratios, a wealth of material which permits decisions to be taken in subsequent matters. But at the same time, this elapse of time which takes place between the original dispute and its final culmination not only postpones the final decision, because ultimately till then the tribunal's decision is tentative, but in the process, it gives time for more of such disputes to proliferate and become a burden, a caseload, which comes up and remains before the tribunal. That is certainly one of the contributions of the system itself to the burden which falls upon the tribunal in terms of caseload. There is another handicap which is no less significant, that sometimes it takes time for a final outcome. And sometimes this final outcome occurs after that original dispute has ceased to exist not because of a solution between the parties, but it ceased to exist by operation of law. For long, we were dependent on decisions relating to manufacture, which, in my opinion, of course, could have been closed once the 1985 Act came in and the Central Excise Tariff Act was sufficient to determine what is manufacture. So in the process, we have a catch-22. The longer time it takes to solve a problem, the problem itself comes to an end, but there are rulings which survive in a different ambience, and which may be applied, and which probably are applied. And there is one key factor which is of particular relevance to all of us. In this form of tribunal dispensation, the right of the state to appeal. We have one of the key litigants being the state, the one who initiated the problem, or one who initiated the issue, and the state being allowed to file an appeal. We had revision before the tribunals came into existence, and the revision was an administrative decision to revise an earlier opinion. Now that revision could have been subjected to tribunal decision, and that would have been the end of it. Instead, at each stage, we have provided a ground of appeal, a forum for appeal for the state. Now let us look at statistics. 75%, ballpark figure, of the cases that come to the tribunal after the SSCs already decided against them. 90% of both sides of the litigation go in favor of the SSC, which effectively means that the decision which is taken ultimately in a court of law is totally at odds with the decision taken originally by the original authority. It is not that there is no system of rectification. In fact, the tax laws provide for what is called review. And this continuation of this dispute, ultimately ending up 90% in favor of the SSE, means that the review system has failed. Because the essentiality of review is not grievance. The state cannot have a grievance. The state has its own means of rectification. The essence is legal and proper. What is legal and proper should be judged by the revision authorities or reviewing authorities, even if it means that the case of revenue has been lost. This is something which needs to be thought over. This is something which the administrative mechanism needs to give focus on, whether the review system is working well or not. Let me come back to Australia. We keep coming back to Australia for a particular reason. Like us, they had the common law jurisdiction which came in there, subsequently got codified. So that is the reason why most often we refer to Australia as a guiding principle, as something which throws light on us. Australia, after 50 years of experience, roughly the same time, probably 10 years more than we've had experience with tribunals, is today conceptualizing the possibility of an alternative to tribunals. It is now open to public debate. 50 years of working. For us, 40 years have passed. Probably it's time for us also to look into it. I leave you with some parting words from Leon Ury. There is this machine which has been crafted, a machine which is to be taken to the middle of the desert for final destruction of some enemy property or enemy persons. The conveyance which takes it has only one use, to carry it there and then along with the destruction to destroy itself. So naturally the refinements of mechanical engineering have not gone into it. And as he puts it so well, he says, there was this machine going along, screaming to the heavens, protesting its own creation. Now it's time for us also to do that. Jai Hind.
Thank you, Mr. Matthew, for a very insightful speech. The requirement for having an adjudicatory structure simultaneously with introduction of any law is very well taken. Also about the increase of batch matters and also the administrative mechanism to be put in place. Thank you so much. May I now invite learned Mr. C.L. Loda to speak a few words. Thank you.
Honorable Shri Justice Pankaj Mittal, Senior Judge of the Supreme Court of India, Honorable Srimati Justice Sunita Agarwal, Senior Judge of the Allahabad High Court, Honorable Shri Dilip Gupta, President of the CSTET, distinguished judges, honorable members of the tribunal, my fellow members of the bar on both sides, members of the CSTET staff, ladies and gentlemen, very good afternoon. I consider it to be a great honor and privilege to be on this podium and to be able to share a few thoughts with this distinguished gathering. And I deeply thank you, Justice Gupta, for this special and rare opportunity. After conceiving of the commendable idea of celebrating 40 years of the CSTET, Justice Gupta intensified his search and tried to locate those who were present and around when the institution was established and who are still around. And very few of us are left, and he spotted me. And I have no doubt, I'm fully aware and conscious that that is the reason I'm before you today afternoon, ladies and gentlemen. Every special birthday, be it of a human being or be it of an institution, is an occasion to pause, to ponder, to reflect, to reminisce, to recalibrate the path that has been traversed and the path that we are going to traverse in future, make the necessary readjustment, and then proceed ahead. Today is such a momentous occasion, and we must do it for this institution to find what have been our triumphs and what have been our tribulations, to get some lessons for future journey. But before I do that, permit me to read an excerpt from a speech of Chief Justice Chandrachud about the state of our judiciary. May I just read a short passage? An effective judicial system requires not only that just results be reached, but that they be reached swiftly. I am no pessimist, but at times I see dark clouds gathering over law's rarefied atmosphere. There is some evidence, feeble I suppose, feeble I hope, of ecological pollution of the Taj Mahal of justice. Long and interminable arguments, whispering of heavy professional fees, the chronic delays in disposal of cases, and may I say, the not so chronic delays in decision making, are all matters which require of the men of law a careful and urgent attention. I hope and pray that nothing that we will do shall tarnish the fair name of justice, which can only come from a keen social awareness which involves a nice and judicious balancing of conflicting interests. I'm sure most of you sitting here would think that I have quoted Chief Justice D.Y. Chandrachud. No, I have quoted Chief Justice Y.V. Chandrachud, Justice Chandrachud's father, and this is what he had said in first Law Day lecture in 1979, 44 years ago. And this is the telling commentary on our state of our judiciary as a whole. So we need to look at that past. Before I do that, in fact, that is the comment of Justice Chandrachud, and followed by various other similar comments, that it was perceived that India as a preferred destination of investment has three great advantages. Competitive labor. We have fiscal laws which are incentives offered to those who wish to come here and invest. And thirdly, and most importantly, an independent judiciary. But because of the backlog in various courts, it was thought that the name of India was going down, and the advantage which we have as compared to our neighbors and neighboring countries of a preferred destination was getting diluted. It was for this reason that the thought came about creation of the tribunals, a body where you will have domain experts, because these are specialized fields. If the tax demands are remaining pending for long, if contracts are not able to be enforced quickly, then your name is tarnished in the international arena. And that is why you create a body which is comprising of people who are with judicial principles as well as with domain knowledge. And that is why you have the merger of technical members and the judicial members. Looking back, sir, when I first walked the corridors of this tribunal in 1983, what did we see? We saw that we have been given best of the members, chosen from CBEC, who were responsible for crafting and drafting the tariff. So they knew the tariff at the back of their hand. But we were given the most pathetic infrastructure. Now, these technical members, they rubbed their knowledge onto the judicial members, and judicial members rubbed their knowledge on the technical members. As a result, while first initial few months, each lawyer had to earn every rupee of their fee by pointing out to them what the legal principles of interpretation were. But they would sit saying that, no, we know the tariff, we know, we have drafted it. So that was the initial attitude for first 2-3 months. It was becoming very difficult. I just happened to narrate a small story of my first interaction with Mr. M.C. Setalwad when I first came after doing law from Allahabad. I was his junior. And this was the third or the fourth conference we were having, during which the others were delayed because of the traffic. I happened to reach. He had little time on his hands. So I went and asked him whether I could be admitted. And then he said yes. So I went in. And I asked him, can I ask 2 or 3, may I make 2 or 3 points? He was delighted. He said yes. Each time I made one point, he would turn to his bookshelf, bring out the book of Constitution, which must have been referred by about 20,000 times, and adjust his lamp and again look at the provision. Again, he'll keep the book back. And this I had seen him doing in various conferences. When he did it third time, I asked him, sir, you have read this provision again and again. You virtually remember it by heart. But each time that I raise some point or anybody else raises a point, you pick up the book and want to read? He said, yes, young man, I have read this and I remember it, but I have not read it in the light in which you want me to read. So each time, this story I just happened to say in the lighter vein. And all those technical members, they must have shared the story with each other. Within 3 months or so, the kind of change which we perceived in each one of them, it was a pleasure to appear before them, it was a pleasure to assist them, and they profusely appreciated whatever was done by 2 or 3 other. Lakshmi Kumaran was there, 2 or 3 other members I see, who were also there at that time. He, of course, had not crossed the fence at that time. You were in the process of doing it. It was a pleasure, and within no time, the tribunals functioned as any good bench of the High Court anywhere in the country. This is what was given to us. But in terms of infrastructure, nothing could have been more poorer. We had leaky toilets. We did not have a lift. So in Bombay, you had to climb 4 or 5 floors, taking your briefs and books. You had no bar room. You had to wait in the corridor along with the clients. There was no place to sit. Those were the conditions in which they worked. They did not have initial computers. I have seen members writing 30 pages by longhand, the judgments. Yet, the institution survived. Institution did very well. The relationship between the bar and the bench was extremely good and cordial because each understood the kind of contribution which was being made by the other, despite the handicaps which were being made available. Sir, whenever I hear about judicial delays, a discussion between judges and various judicial forums as to what should we do, I'm reminded of a story of a king. A king was very fond of throwing good parties and having very good feast. So he collected 50 best chefs in his kingdom, gave them some kitchen and some utensils, and turned out best feast possible in all over the area. The people knew so a lot of people will come. The ministers had a bit of poor language. So sometimes instead of inviting some couple, they will invite the whole family. Sometimes inviting for a day, they'll invite people for a week. So suddenly you did not know how many people will come, what kind of crowd will be there. Chefs will just peep out. Chefs were not informed. What would be the kind of, what is the guest list, how many people will come. And this kept on while the allocation was being made to all other ministries. To these chefs, no further allocations was easily made. Yet, when the food was delayed and the queues became long, they were asked the question, why so much of delay? They were very noble, so they came and sheepishly explained, without asking, and telling them sternly, if you do not give me the infrastructure, do not give me the facilities, how do I cook? The state of the judiciary in India is exactly the same. Sir, what have we allocated to judiciary in last 7 decades? Sir, in 2002-2003, the allocation to Ministry of Law was 519 crores out of a budget of 4,30,000 crores. In 2022-23, we allocated 4,055 crores out of a total budget of 39.45 lakh crore. This is 0.01% of GDP. Consistently, for last 7 decades, the allocation to us in judiciary is 0.01% of GDP. With this kind of allocation, what else do we expect? So that is the first major cause of this difficult situation that we are in. The second and most important is the absence of judicial impact assessment. Whenever any law is brought, whenever any amendment is brought, there is no judicial impact assessment which is made. How many new cases will be created? What kind of facilities do we need? No impact assessment of that. Only by 138, Section 138 amendment, we have added 33 lakh cases. As on 1st March 23, we have 33 lakh cases pending of Section 138. Now, this was never anticipated. We just made one amendment, and suddenly the judiciary has 33 lakh cases to handle. Now we debate, we hold conferences, devise ways and means, how do we expedite it? Same we have done for various laws. Same we have done for various amendments that we have made. We don't ever think, as a result of this amendment, how many more cases will be generated, what kind of infrastructure is needed for that. Sir, that you are present here, and I'd seen and read what great work you did in Jammu and Kashmir while you were the Chief Justice there. A mega complex of High Court is being planned there, and within 1.5 years, you did the project for Kashmir, you also did the project for Jammu, which is in a very advanced stage of completion now. That was made possible by virtue of your good relations, without affecting the independence of judiciary in any manner, with the executive heads. The name of the game, sir, is collaboration, not confrontation. It is collaboration and which opens the keys of all locks, not the confrontation. Justice Gupta has achieved here in this short time. This conference or this celebration is the first such celebration in the last 40 years. We have 19 appointments in one shot. Again, the first in the history of the tribunal. This reminds me of a little Hindi. जब अंधकार से लड़ने का संकल्प कोई कर लेता है, तो एक अकेला जुगनू भी सब अंधकार हर लेता है. The third cause of this situation where we are in is the kind of ill-drafted laws and the frequency of amendment. Sir, kindly look at the GST law. This was in the pipeline for over 20 years. Various governments, various bodies were discussing it. Within first 6 months of the bringing out of the law, kindly see the number of amendments made. Who has asked the question to the people who are responsible? What were you doing? Why did you not think of it earlier? To my mind, every amendment must be questioned. It is like you're repairing a new building within no time. How can you do that? So this is not the way to draft. The fourth problem is a problem of backlog. We have huge pendency. We have 5 crore cases pending, 4.3 crores at district level, 60 lakhs and odd at the High Court level. We also have a big pendency in the Tribunal, which is now being slightly brought down, but it's still the pendency is there. So pendency is also on account of some practices and some provisions. Let me give 2 illustrations. We had the requirement of pre-deposit. Only then the appeal would be heard, unless you have it waived. We had a full-fledged hearing before the tribunal. Almost up to the end of the day, all the only stay matters were heard. So virtually you have doubled the pendency. Same matter you are hearing first on the stay hearing, and then again when the final hearing comes. Today the backlog, I would say 70% of the backlog is because of that provision. We did away with that provision. We said you deposit X percentage, and then we will hear you. You see the things have moved, and things have moved. Likewise, we had the litigation on valuation. We had so much of litigation on valuation. You brought a provision, MRP, less abatement. Now, once that came, and it suited everybody, after arguing at length as to what abatement can be there, if I could get only 35%, and government was willing to give 45%, because the right-hand side is with you, you increase the rate. You only want a certain revenue. So as long as your revenue is assured, please do not have provisions which will block the whole rail of litigation. So the courts also must do that. In the morning session, I think the chairman CBIC made a very valid point that there should be a bit of collaborative talk between various stakeholders. Yes, we are litigants on each other side. Government is a litigant. Tribunal is an independent body. But this must be conveyed to them. Look at, sir, what you mentioned about Chandra Kumar judgment, Sampath Kumar judgment, and Madras Bar Association judgment. There are 2 ways of looking at the same, sir. One, that we have such a strong judiciary. Each time the government has passed some kind of a provision which is not meeting with the constitutional provision, we have struck it down. Excellent. So we have a very robust judiciary, must be lauded. But sir, in the process from 1990, first time the judgment came, till 2023, we are at square one. They have repeated the whole exercise. Your Lordship will know Madras Bar 1, Madras Bar 2, Roger Matthew. They are repeating the same thing ad nauseum again and again. But government is not doing anything. They'll make a minor modification, again a litigation, again 5 years, they are back to square one. As a nation, we have lost 30 years, which are very, very critical. We are at the same place. With this kind of a thing and non-collaboration, how can you proceed further? It will never happen. You will continue to be at the same square. So that is what is needed. There has to be a joint sitting where we can agree. Look at, sir, GST. This tribunal has done so good work, despite all the handicaps, despite lack of all facilities. In Jammu and Kashmir, in the High Court building, hold your breath, there are 720 lawyers' chambers provided by Justice Mittal. Am I right, sir? 300 on one wing, 420 on another. 720 rooms for lawyers' chambers. So I'm mentioning this because you can possibly get it done, not as a complaint. But we have not a single lawyer's room, lawyer's chamber, in any of the locations that we have, in any of the tribunals, for last 40 years. Now, if this is the kind of, in place like Bombay, in place like where the coming is so difficult, Bombay, Calcutta, etc., if the cause list shows all matters at 10:30, every lawyer has to come. And every day we keep hearing, which one will be taken up first today? Customs, excise, or service tax? Every day's query. With great respect, why should it be? What is the difficulty in saying we will hear this and that's it? So only those lawyers will come with that preparation. A lawyer comes with preparing all the three. Obviously, he has limited time. So his preparation is not at the best in either of the three. And so therefore, this is the difficulty. There should be no difficulty in telling in the cause list as to which matters we'll take and making an assessment, how long will it take? Keep some at morning, keep some in the afternoon. So lawyers will not waste their time. The whole crowd is there, whole day, and the bench feels pressurized because so many are waiting. So therefore, you rush people. That all can be easily avoided. These are minor things which are easily doable. Likewise, judgments, as somebody, your Lordship rightly pointed out. But within 1 month, judgment should be possible to be delivered easily. It will be fresh in your mind. We have the technology. We can record the submission. We can replay the submissions. Do it within 1 month. Otherwise, afternoon session, don't grant the hearings. If the board you feel is likely to be taking long, kindly discharge the board so that lawyers can go and do some other work. So both are free. You are free to concentrate, not feel pressurized, and they can also do. Sir, our infrastructure, since your Lordship is present, may I just leave one small suggestion on the table? We have 766 districts in the country. The estimation by the Law Ministry is that we need 15,000 courts with an outlay of 10,000 crores. So all we need is 10,000 crores to construct 15,000 courts in 766 districts of the country. By past experience, we know allocation will not easily come. We have successful experiments in Bombay where slum redevelopment has been done in exchange for FSI. So there are slums. Builders have been told to clear the slums, give the slum dwellers a pakka house. In exchange, you are allowed to build. You build extra FSI. So he makes a little money, whatever he has spent on that. So nation has not spent anything. Construction has been completed, and this has been done. Similarly, municipal car parks of 400 to 600 cars have been constructed in exchange for extra FSI, and they have been allowed to do it. We should have an assessment of the national need for the next 25 years, whereas your Lordship said everybody must be located here, all tribunals must be located here. Future, we may have to put some special courts because of provisions like 138, etc. Have them into account, make those provisions, and tell these 10, 15 top construction companies in the country to bid in a very transparent and fair manner to do this. It can be easily done. Country does not pay anything. Government does not have to increase the allocation. So it can continue to be 0.01% if they so desire. And still, things are done. So this is something which your Lordship can, just as a suggestion, so right quarters, this can be possibly considered. We have it successfully done in place like Bombay. There are two small suggestions which I have, sir. The need is to ignite the ecosystem. We have extremely bright minds. They need to be ignited. Your Lordships have wisdom, sagacity, knowledge, passion, everything. But that is not transmitted to the next generation. The way to do it, perhaps, would be that from each state draw 2 members of the lower judiciary, the judges in the district courts who would be about ready for elevation, to spend 1 year with every Supreme Court judge for 1 year. 34 into 2, so 68 persons are trained in 1 year. In 5 years' time, sir, you will have half the population of the current High Court judges having been trained by or having spent 1 year with you. People go for 6 weeks, 8 weeks, Harvard course, and think their wonders have been done to them. Kindly imagine if judges were to spend 1 year with, your lordship. What great, A, it will give you assistance during the period that they are there. B, but more importantly, they will learn how the system works, what Supreme Court wants, how the councils argue, how the notings are done, and the same would be replicated in the nation within 5-6 months. So within 2 years or 3 years, when the infrastructure ready, this would be done. Same should be done with the tribunal. Tribunal members have no assistance today. If in any matter they are not properly assisted by the arguing counsel or the SDR in any matter, they have to do their own research. An intern could be given, bright law interns are there, an intern could be given to all the legal members, and a joint commissioner level person who is about to become commissioner appeals spend some time with the technical member. Once he goes back and becomes commissioner appeals, he will understand what needs to be done. Now, your inflow of new cases would substantially reduce. Today, there is no system of keeping, like you rightly mentioned, if some administrative officer is passing the order, which is ultimately coming to the tribunal, there is no system of noting which administrative officer has passed what judgment. He can pass an outlandish demand, an illegal demand, but nothing is noted in his personal file. There should be a system to note how many orders this officer has passed, how many have been upheld in the future, like what we do for after tribunal onwards. How many judgments have been passed, how many have been upheld, what is the success rate, all that can be taken off. And one last point about the clearance of the backlog. We were talking about technology in the session prior to this. We have about 5 crore cases pending. Data mining is one of the major possibilities now, both with artificial intelligence and machine learning. Blend them together. We are not wanting predictive artificial intelligence as to what will happen to the case. No, only data mining. So all case records would be data mined. And we will find out what are the issues involved there. Doing it manually is a Herculean task. If that can be done, then you will know, okay, we have 10,000 cases, 5,000 issues to be resolved. Constitute bigger benches, five judges benches. Give authoritative pronouncements, and you will have total disposal of the whole within a short period. That can be considered. Sir, but most importantly, I think whatever is the nectar of knowledge, and particularly the sagacity and the wisdom your senior judges have, must be transmitted to the next generation. That is my humble submission, that this is what must have. Just as the fragrance of a flower, the flower does not wither away until it has distributed its fragrance to the air. सुमन, हर सुमन का सुरभि से यह अनलिखा अनुबंध है, अनिल को सौंपे बिना मैं झरूं सौगंध है. Every flower has an unwritten contract with the fragrance, that until I will pass on my fragrance to the wind for the dissemination of fragrance to all, I will not go, I will not wither, I will not die. Thank you very much for your patience. Thank you very much.
Thank you so much, Mr. Loda, for your lovely insight into the starting of the tribunal, the CGAT, and the experiences at that time, and also the interaction with Mr. Setalvad, and all your suggestions, valuable suggestions which you have said, and I hope it's implemented soon. Thank you so much. I think I'll have to introduce, I'll have to speak myself for a couple of words. So thank you so much. Honorable Justice Pankaj Mittal, Judge Supreme Court of India. Honorable Justice Ms. Agarwal, Judge Allahabad High Court. Justice Dilip Gupta, President Sestat. Mr. Matthew, Mr. Loda, and dear friends. In a civilized society, various freedoms enjoyed by people act as a conducive ground for favorable business opportunities and spurt in growth. When such activities start to significantly touch lives of various persons in the society at large, the process of regulating the activities commences, with acts, rules, regulations which being enacted, and the implementer of such rules and regulations being the government. Such a scenario brings with itself differences in the perception regarding the scope and depth of such regulations, and thereby disputes which need to be adjudicated, keeping in mind and securing the interest of the businesses, the government, the citizens, and other persons concerned. Till the third quarter of last century, the growth in various sectors of economy was rather slow, and traditional courts were the adjudicatory structure which was available and was sufficient to take care of interstate disputes between the parties. During the last quarter of the 20th century, the product innovation and its obsolescence started racing with each other. The technological growth, as well as the growth in service sector and manufacturing sector, tested the economy of scales beyond any limits, and the reach of businesses went beyond the national borders. The ever-expanding economy and trade pushed India from being Robinson Crusoe, stuck in an unconnected remote island, to being interwound with transnational corporations originating from overseas, and later, transnational corporations originating from India. These transnational corporations, along with expansion of digital network, internet, advent of supercomputers, cloud storage, international supply chains, and manufacturing of final product different geographical locations, have taken the economic activities to a different level altogether. The traditional laws and adjudicatory mechanism were inadequate to tackle such a burst in the area of business activities and the need of special adjudicatory structure as well as regulations like transfer pricings, anti-dumping, etc., in order to strike a balance between the equities of all the stakeholders required. This is where the tribunals fitted in like a glove with technical members who possess special and distinct knowledge in activities which touch those special areas of operation. And the tribunals have evolved with judicial members bringing in their area of expertise in adjudicating process, making the said structure effective, efficient, economical, and speedy in terms of justice delivery. The tribunals have freedom of not following the strict rules of Civil Procedure Code, nor the rigors of Evidence Act. They can follow their own procedure, and judicial members bring in their expertise of following principles of natural justice, as well as being consistent and positive while delivering judgments. The experiments with tribunal started in India with Income Tax Appellate Tribunal in 1941. The said tribunal was established under the Income Tax Act 1922 by way of amendment in 1939. Later, by way of 32nd Amendment to the Constitution, Article 371D was enacted, establishing Administrative Tribunal for the state of Andhra Pradesh as a substitute at that time for the court in matters pertaining to civil service of the state. It is important to note that Article 136, being the provision for special leave to appeal to the Supreme Court in respect of any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal, 136 had the word tribunal, in the territory of India. Though the word tribunal has been used in the Constitution, The tribunals that we know of today have been established by tracing the life to Article 323A and 323B, which has been spoken by all other previous panelists, of the Constitution, which was introduced by the 42nd Amendment in the year 1976, with effect from 3/1/77. 323A pertains to administrative tribunals, and 323B pertains to tribunals for other matters, including land disputes, taxation, etc. The Parliament and the Legislature have the power to establish tribunals under 323B in respect of all entries in 7th Schedule of the Constitution. The 42nd Amendment to the Constitution came about by way of fine-tuning by different committees and commissions, as has been said by my previous panelists. Honorable Justice J.C. Shah Committee, also referred to as High Court Arrears Committee, in the year 1969 recommended tribunals for the service matters. Administrative Reforms Commission also recommended the same in 69-70. The 6th Law Commission, as well as the Swaran Singh Committee, also recommended tribunals for service matters as well as for land disputes and taxation in the year 1974-76. These led to the 47th Amendment to the Constitution in respect of tribunals. All the tribunals for different specialized areas have been established under various statutes. Their lifeline and strength are derived from the provisions of the Constitution. The Honorable Supreme Court of India has, from the year 1986 onwards, dealt with constitutional validity as well as various aspects of tribunals. As has been said by my learned friends before me, to name a few, S.P. Sampath Kumar was the Union of India, Chandra Kumar was the Union of India, R. Gandhi was the Union of India, Madras Bar Association, Roger Matthew was the South Indian Bank, are cases where Apex Court had observed the importance of the tribunals and fine-tuned the appointment and tenure of chairpersons, president, members of the tribunal. As has been said by Mr. Lodha, again and again, 30 years have been lost from 1990 to 2022 or 2021. Any anomaly which was found earlier stood corrected. One of the main grounds in respect of members and president and chairperson of the tribunal was that they were appointed for a very short tenure at that time, and that the method of appointment gave government a strong hold in the way the judgment of tribunals would be tilted. It was also said in a lighter vein by commentators of tribunalization that the tribunalization is leading to trivialization of justice delivery system. Keeping in view of the pronouncement of various judgments of the Honorable Supreme Court, which I had mentioned earlier, the Tribunals Act 2021 was enacted, and it has put to rest such doubts in minds of all the stakeholders. At least from now on, we should have no doubts about the tribunals. The Parliament has undertaken the exercise of merging some tribunals with some which has common areas of operation, and amended the acts under these tribunals have been established to give effect to the provisions of Tribunals Act 2021. While we analyze any subject with a view to judge whether it has met the purpose for which it was made, one must see all the elements which make up that subject. In case of tribunals, the three segments which you should see are, firstly, the law regulating the special activity, secondly, the adjudicatory structure, and thirdly, and finally, the justice delivery. The law and adjudicatory structure has been evolving to meet various changes that have taken place in the last quarter of the 20th century, as well as continuing till now. This is when the rapid industrialization of new products have been coming in. Like I said, the race between the innovation and obsolescence had taken place. Before that, one ambassador car would come in and it would run for 30, 40 years. Now, every 6 months or 7 months, a new model comes in. So that's when it's an emerging economy, and economy is just exploding, and world has become borderless. That's why the new regulations have been coming in, because it's touching the lives of all the people. And new regulations mean new adjudicatory mechanism. As Mr. Matthew said, there should not be any time lag between the adjudicatory mechanism to be put in place and a new law coming into place. So all those things have been happening. So I'm looking at it to a more positive side. So to take the example, for example, Company Law Board, which was established in May 1981. Under the Companies Act 1956, adjudicating primarily the matters relating to free transferability of shares, rectification of register of members, oppression and mismanagement of companies, as well as conducting special audit for checking whether there's deviation of funds, etc. BIFR as well as AAIFR were established in the Sikh Industrial Companies Act 1985 for the purpose of rehabilitation of companies whose net worth had eroded, with a view to making the net worth positive, if possible, instead of letting it go into liquidation. For the said purpose, an operating agency, being one of the financial creditors, would draw up a plan for the purpose of rehabilitation. The company was, however, firmly in the hands of original promoters who were responsible for running down the company. Various financial creditors and operational creditors would have to take a haircut, and the person responsible for bringing down the company, being the promoter or director, had they gained from such a scheme. There was fine-tuning done to take care of interest of financial creditors by introduction of securitization and reconstruction of financial assets enforcement of Security Interest Acts 2002, SURFACE Act as we know it, and DRT and DRIT were set up as adjudicatory structure. The provisions of SURFACE Act enabled the financial creditors who had given 3/4 of the credit to the Sikh company to come together under the SURFACE Act, resulting in the reference before BIFR or AIFR to abate. And they could use the assets of the company to maximize whatever they could gather from the, to take back the loans by using an asset reconstruction company, etc., under the SURFACE Act. There has been further refining the process. National Company Law Tribunal and the National Company Law Appellate Tribunal have come in and established under the Companies Act 2013, as well as the Insolvency and Bankruptcy Code 2016. The concept of rehabilitation plan has now been transformed into a resolution plan under the IBC. And the promoters and directors who ran down the company, who were responsible for bringing it to loss, have been debarred, they've been debarred from participating any further in the resolution plan by categorizing them as persons ineligible for participation. So one can see the tribunals as well as the regulations and the regulators have undergone various iterations and fine-tuning to reach the stage in the last 40-odd years after the 42nd Amendment to the Constitution. To take another example, Electricity Act. I go quite a lot to the electricity tribunals and regulatory commissions, APTEL, established various state electricity regulatory commissions, an appellate tribunal for electricity. It had distanced the government from any activity even remotely connected with fixation of tariff and power purchase, etc. In the working of the state electricity regulatory commissions, various fine-tunings have been done by way of regulations, by introduction of multi-year tariffs, truing up of the revenue requirements by checking the actual audited figure at the end of the year and the estimated figure at the beginning of the year, so that any profits made by way of excess collection or any shortfalls may be made by, may be offset by reducing or increasing the revenue requirements for the subsequent year. This balances out the equities between generating company, distribution company, as well as the consumers. In case of CESTAT, which was earlier known as CGAT, the harmonization of classification of commodities nomenclature it made a huge impact on reducing the disputes regarding quantum of duties payable. I too, when I started my practice first, I was an engineer to begin with from 1981 to 1993. And 1993 I started my practice, and my first tribunal was CGAT. And we used to go, and most of the cases were on classification. And over a period of time, once the harmonization was done in 1988, and after that, the number of cases and number of disputes reduced, and I had to also move to other tribunals then. So, this harmonization came in 1988, nearly 6 years after CGAT was established. And the said harmonization of classification is an ongoing process which is done every 6 years or so by the World Customs Organization under the Brussels Convention, of which India is also signatory. It is often seen that tribunals are sitting ducks for being criticized, and the talk of bringing all these subjects handled by tribunals within the jurisdiction of courts is never ending. It is needless to mention that tribunals are as special as ducks, which can fly, swim, or walk on land. The tribunals have come this far in the last 40-odd years through various improvements in their functioning, manning, fine-tuning of laws and regulations, digitization, etc. And it is an irreversible process and can only progress from strength to strength. As a closing remark, I would like to suggest certain changes and leave it on the table for the improvement and overall working of the tribunals. Tribunals derive their strength from Article 323A and 323B. They may be established under any act, but basic strength comes from Article 323A and 323B of the Constitution. And they are expert bodies. And they should be allowed to test the vagaries of rules and regulations which are subordinate legislation made under the respective acts. This would lead to ease the burden of high courts, which are dealing with such challenges of vagaries under various special acts. Of course, the tribunals would not have the jurisdiction to test the vagaries of its own parent statute, being creature of the statute, and such challenges of vagaries would be handled by the respective high courts. Honorable Justice Ravindran has, in a paper written by him recently, recommended the judiciary should encourage ADR process. So this is the second suggestion which I would like to leave it on the table for discussion later. In the initial years, Central Electricity Regulatory Commission, which is established under the Electricity Act 2003, followed a practice of pre-litigation roundtable meeting between parties to litigation, wherein honorable members and chairperson would also be present. The endeavor of such a preliminary informal hearing was to reduce some of the issues which were there for adjudication. And only limited number of issues would be taken up for a formal hearing. So some of the issues would be thrashed right at the beginning by a round table. It was something like a mediation, where the teeth is given because the judges are also present, the warring parties are present, the state-owned distribution companies and the private generators, everybody is there, and they say, okay, we can leave this, okay, we'll concentrate on these two issues. So instead of having 7 issues going before the judge and having the full day of litigation, you reduce the number of issues to be adjudicated. There's one form of reducing the load. Such a practice can be undertaken by all tribunals, and this would reduce the workload, thereby increase the productivity. Honorable Justice Y.V. Chandrachud, not D.Y. Chandrachud, while delivering the judgment in Kamal Kanti's Datta and Union of India with regard to tribunals for service matters, opined that they should be the final arbiter of controversies relating to conditions of service, including vexed question of seniority, and it may save courts from an avalanche of writ petitions and appeals in service matters. The proceedings of such tribunals can have the merit of informality, as they are not tied down to strict rule of evidence, and they may be able to produce solutions which will satisfy many and displease only a few. Taking a cue from this, of what Justice Chandrachud has said, it is my suggestion that appeals from decisions of tribunal should lie directly to Honorable Supreme Court on questions of law. Certain special acts have such a provision, but it needs to be across the board. Like it was suggested that even procedural law should be same across the board for all the tribunals. This should be across the board. And it will make justice delivery process speedy, effective, and efficient. However, under extraordinary circumstances, litigants do always have the liberty to approach the respective high courts under Article 227. Finally, I would also like to suggest, as has been suggested by Mr. Loda, law clerks should be made available to members and president and chairperson of tribunals, the same way they are provided to judges of constitutional courts. This will increase the efficiency and the working of the tribunals. I would like to conclude by stating that tribunalization plays a very important role in providing speedy and effective justice in specialized areas to all stakeholders, and it seeks to achieve the same objectives of a court, that is to impart and deliver justice to all. Thank you very much.
धन्यवाद। अब हम अपने कार्यक्रम के अंतिम चरण तक पहुंच चुके हैं। मैं वरिष्ठ अधिवक्ता श्री विक्रम एस ननकानी से आज के संपूर्ण कार्यक्रम के सारांश को प्रस्तुत करने का अनुरोध करूंगी। इससे पहले कि श्री विक्रम एस ननकानी सारांश प्रस्तुत करें, उनका स्वागत पादप और स्मृति चिन्ह से किया जाएगा। सो मैं श्री समीर सूद से अनुरोध करती हूँ कि वो कृपया श्री विक्रम एस ननकानी को एक पादप के माध्यम से उनका स्वागत करें। धन्यवाद। अब मैं सुश्री तुहिना सिन्हा से अनुरोध करती हूँ कि वो कृपया वरिष्ठ अधिवक्ता श्री विक्रम एस ननकानी को स्मृति चिन्ह देकर उनका स्वागत करें।
Before we ask Mr. Vikram Nankani to sum up today's discussion, though of course Vikram needs no introduction, but still it's my duty to say a few words about him. Vikram is a designated senior advocate. He's an India qualified lawyer at the bar since 1986 and completed LLM from Government Law College, Mumbai in 1998. Vikram joined the chamber of Mr. Ashok Desai, senior advocate and former Attorney General of India. Between 1986 and 2003, Vikram appeared as counsel in a variety of matters concerning commercial dispute, corporate matters, economic offences and criminal cases, tax, shipping and arbitration. Vikram is acknowledged by Legal 500 as a leading individual practitioner in dispute resolution and litigation in India. He also regularly appears before various high courts and the Supreme Court of India and has, to his credit, several landmark judgments rendered by the courts that have been reported by various authoritative journals and reporters. Vikram has also been invited as an expert lawyer on various occasions, including in Singapore court and arbitration proceedings. Vikram has appeared for and before the regulatory bodies in India dealing with foreign exchange cases, electricity, competition, foreign trade, security market, etc. Vikram has more than 350 reported cases to his credit. Vikram has also appeared before several international arbitral tribunals. May I now request Mr. Vikram Nankani to kindly sum up today's discussion.
Yeah, that's fine. My Lord Justice Mittal, whom I had the privilege of appearing 1 week before my Lord's elevation, my Lady Ms. Sunita Agarwal, my Lord Justice Dilip Gupta, other dignitaries, fellow members of the bar, honorable members of the tribunal, past and present, ladies and gentlemen. For a lawyer to summarize and conclude what has happened today, it's very simple. I can just say, I can't put it better than your lordships, and end it here. Especially with the galaxy of speakers that we have had since morning and the panelists who have really illuminated this entire day. So it is a very unenvious task for me to summarize. But given the role that I have, I can't fail in my duty. I still remember the first day in the early formations of this tribunal when I walked as a law student with my father for a hearing before Justice Fauja Singh Gill. Justice Gill was the first president of CSTAT. And ever since then, that has been my hunting ground. So really owe a lot in personal terms to this institution. And it's really a privilege for me to stand here on its 40th anniversary. This is one institution which has evolved and seen a number of changes and yet laid down the law with a lot of clarity and certainty. It has seen the shift in, remember the Bombay Tires International Judgment had just come out in 1984, and a new concept from a wholesale crash price, which we all learnt in Voltas, to a new valuation regime. This is the tribunal which then evolved its principles further. It saw the advent of MODVAT. It saw the introduction of service tax. It saw thereafter the changes which were brought in the form of the new valuation rule in 2000, that is the transaction value mechanism. it has thereafter seen Senvat principles being relayed and reintroduced in 2002 and later in 2004. Now, why am I getting into this narrative? Is because I'm still an optimist and I don't believe that this tribunal has got a limited role to play in the future with the advent of GST, and something I will make a comment on it at the end. These principles, which provided not only business tools to 4 to 5 journals dedicated exclusively to excise and customs and service tax cases. We had all of them reporting only these judgments, which shows the wealth of the knowledge bank that you have created, the wealth of precedents for the future, the progeny to follow. And I dare say that many of these principles on valuation, on Senvat credit, on classification will hold good even when GST tribunal comes into its full force. And this is the kind of contribution that this institution has made to the evolution of law on indirect taxes. The session started today with my Lord Justice Maheshwari telling us that we should have a kind of a litigant who is more responsible rather than a compulsive litigation. I think these words carry a lot of weight. In any system, it's all the stakeholders who have a role to play. We as members of the bar certainly have a role to play. I think like someone said that you file bulky paper books. I think Mr. Ramanan said you file bulky paper books. I think we should share that blame with the department, because when you have, and if I may use a very technical term which is used in the tribunal, which is RUD, relied upon documents, if you have 11,000 pages of relied upon documents, you can't expect a paper book to be less than that. And to that there will be added more of the contribution from our side, which will be the technical books and the Kirk Authors and the encyclopedia. So I think somewhere that rationalization has to happen between both the bar and, of course, the executive. But I think it starts fundamentally somewhere at the rock bottom stage. It starts firstly at the place where you feel the need and necessity to issue a show cause notice. And here I would say that there is a failure of the parallel support system, which I call. So you have other mini institutions like the Settlement Commission, the advance ruling. With the GST, there was a lot of funfair about saying that there will be pre-consultation stage before the show cause is issued. I would say, in my humble opinion, that to a large extent they haven't really kicked off or taken off in the manner that they should have these parallel support systems. So what is the net result? The burden has fallen on institutions like the tribunal. Hence, it's important that we as stakeholders, members of the bar, and of course the department, both should contribute. We spoke about, I think speakers have also spoken about having interns for members. Maybe that is a desirable step, and we should have it like you have it in the High Court and the Supreme Court. You have interns. And the members of the tribunal, I don't see any reason why they should not have. But I have another small suggestion, and that is to say that in the departmental service rules, and I'm sure Mr. Singh here will agree with me, and many of the other DRs have in private conversations also said the same to me, that there should be a compulsory posting in tribunal for some time in their career, maybe 6 months, maybe 1 year, but it's important because that always gives you the experience of where the shoe hurts on the other side. And then you know how to become a more effective contributor in the justice delivery system. So I think that is one other aspect that I would like to emphasize, apart from the various other measures that would be taken. The session on information technology and also the use of technology today in the justice delivery system is considered was a very, very interesting one, with Justice Sachdeva giving an excellent presentation of that. We all know, and this is a reality which is staring at us, which is artificial intelligence and machine learning. There's an excellent book written by an English professor, Dr. Richard Susskind, which says End of Lawyers. I'm not scaring everybody here. But the fact remains that law is getting more and more standardized, and it is going to be commoditized and packaged. And this is exactly what Richard Susskind's book says, that if you do not reinvent yourself and you do not become a bespoke lawyer, you're going to perish because law is going to be standardized. We are seeing that happening in small way in many countries. So small consumer disputes, motor accident matters, getting a ticket from a traffic cop, all these issues are today being decided online by impersonal, quote-unquote, faceless judges. I know the word faceless in India would stir a lot of controversy, but that's what it is. And I think we should be squared up to that reality that today or tomorrow, there is going to be an inevitable intrusion of technology, and that is a much desirable intrusion which we require in our delivery system. So with Justice Sachdeva and other speakers talking about how technology can improve, I'm sure that this tribunal is also going to rise to greater heights under the able leadership of Justice Gupta, who has, to his unique distinction, perhaps the longest serving president of CSTAT. And amongst the various firsts that were narrated, I think this also is something that we really acknowledge and respect him for. And I'm sure that, as I said, even though there is a threat of a new GST tribunal coming into force, I think the government has its own compulsion of how to set up this GST tribunal. And as I understand, I'm very distant away from the policy makers, but what I understand, the challenges of trying to integrate the state tribunals with the central tribunal is one of the challenges. But I'm sure that with Justice Gupta at the helm of affairs, we are going to find a middle path whereby this tribunal reaches many more heights, and I'm sure that we will again meet when we celebrate the 50th golden anniversary of this tribunal. Thank you so much.
Thank you very much, sir. May I now request Shri Binish Kumar, Registrar SESTA, to kindly present the vote of thanks.
Honorable Mr. Justice Pankaj Smith, Judge at Supreme Court of India. Honorable Mr. Justice Sunita Agarwal, Judge Allahabad High Court. C.J. Matthew, Honorable Member Technical. Honorable C.S. Lotha, Senior Advocate. Honorable Gauri Shankar Sai Kumar, Advocate. The subject, experiments of tribunals and triumphs and tribulations. The discourse on that has benefited the audience. Honorable Mr. Justice Pankaj Mittal has emphasized the importance of the tribunal, and that has given us a confidence that the highest court of the land has taken care of the importance of a CSTAT. Honorable Ms. Justice Sunita Agarwal, the perspectives in her speech has given so much of insights for one to think of. And C.J. Matthew, Honorable Member Technical, has touched both the ends of the tribunal, the lower authorities and the higher courts, and the future of the tribunal. And C.S. Lotha sir has took us through the early days of the tribunal, telling the state of the tribunal, and beautifully described us. Why should there be collaboration than confrontation? Honorable Gauri Shankar has enlightened us with important milestones in the formation of the tribunal and the important case laws. On behalf of CSTAT, I thank each and everyone in the panel from the bottom of my heart. I thank all the members of the tribunal who have come from the regional benches and attending the program and making it a success. I thank all the members of the bar, not only the assisted bar, but also the High Court bar, who have attended the program and making it as a success. And I thank the Registrar General of this High Court for providing this auditorium and giving us a feeling that it is our own auditorium so that we could come every time and go to prepare for this function. And a special thanks to the Office of the Chief Commissioner AR that they have taken, with their support, only this function could become successful, because especially on the side of the catering. And during the lunchtime, when we met, the commissioner was telling that there were about 500 people who attended the inaugural program, how it provide. But there was no panic in their face. So everything was taken care. Thank you very much. And lastly, thank our own staff who have, there's always a doubt with the sister staff that they will not face challenges. But today it is proved that the sister staff is ready to take up any challenge. And the opinion is that it is the first time in the history of sister that such a big event has happened. And lastly, but not the least, why I put this last? Because when this judge, if somebody comes to his chamber as a guest, however insignificant the person may be, the tea is served first to that person, and the last tea will come to his table. This is none other than our own president, Justice Dilip Gupta. And this program was conceptualized and organized within a short period of time. We had a celebration during the 25th anniversary, but that took 1 year, a full 1 year of preparation. But within a short period of time, how could it be possible? When this was told to our staff, many of us, including me, have doubted how it could be possible. But when we look into the His Lordship's credentials, when His Lordship was the judge of the Allahabad High Court, one can recollect, everyone knows that the 1 crore cases with the 50 crore pages to be digitalized within a short period of less than 1 year, and His Lordship made it possible. And Matthew sir was telling that we should look to the Australian system, but Australian government invited His Lordship and the team and to see that how it worked. And with that experience and expertise, for His Lordship to organize such a program is nothing but the tribunal actually, when His Lordship was taking as the presidentship of the tribunal, the tribunal, many of the members may be knowing that the members were used to write the daily orders by hand, and there is an order sheet on every judicial files. But now they see by the time most of the other tribunals have advanced much in terms of technology, using technology, and we were way behind. But in a very short span of time, His Lordship has introduced so much of reforms that we are now much ahead of that. And it is proven during this COVID period that there was a lot of disposals than any other tribunals, to the credit of Sistat. And today, in the morning, we started with this logo. This is glorious. And throughout this day, everyone was doubting about the pendency of cases. And yesterday, I was reading from the archives of the newspaper, The Hindu, in which this news appeared 50 years ago on March 17, 1973. The Union Minister of State of Law and Justice, Mr. Needhi Raj Singh, described the delay in execution of justice as chronic and most depressing, and said the government was trying to simplify procedures for expeditious disposal of cases by the judiciary. Addressing a press conference convened for the first time by the Press Information Bureau of the Union Government in Indore on March 13, Mr. Nidhi Raj Singh admitted that over 73,000, 64,000, and 40,000 cases were pending before the Calcutta, Allahabad, and Bombay High Courts, respectively, besides 12,000 in Madhya Pradesh. I was wondering if this minister is today, he would frown out the number of the cases. But the glory of the tribunal lies not in the terms of the disposed of the cases, which I want to clarify. I use this opportunity to clarify the quality of the judgment which is being given by the tribunal, which is most of the judgments. And we sitting in the registry, we know that in the last 5 years at least, there's a very rarely that we get a remand from the Supreme Court. That shows the quality of the judgment delivered by the tribunal members, and we are very proud of that. And I request all of the audience to stand and give a hand to our President, Justice Dilip Gupta. Thank you so much.
One small request which is only for the members, honorable members of the CISTAT. They are all requested to kindly stay back. This is under the instructions of the Honorable President. Maybe,